On the supplementary list under heading for to be mentioned, item 1, DA 3016 of 2026. इसमें क्लियर जो है बेस नंबर का ईयर में 25 लिखा है 26 नंबर
इस नंबर को ये नंबर the matter has been listed at the instance of the office indicating that the case number of the bill application has been mentioned as BA number 3016 of 25 instead of 3016 of 26. Ready to the records. The order dated 24/26 is hereby modified, and the case number is directed to be read as BA number 3016 of 26 instead of 3016 of 25. Office is directed to carry out necessary correction.
Item 2, DA 3346 of 2026. इसमें देखिए ऑर्डर डेट भी है
Order date to MHA.
2 3 4 हो गई 4
The matter has been listed at the instance of the office. In order number 2, the date of order has been wrongly mentioned as 21/26 instead of 21/4/26. Where is the record? The order number 2 is accordingly modified, and the date of order is directed to be read as 21/4/26 instead of 21/2/26. Office is directed to carry out necessary correction.
From the daily call list under heading for fresh filing, item 1, DA 1960 of 2026.
Under section 70 of the Protection and Prevention of Corruption.
It's like that. Practice.
Yes, sir. Well, the petitioner was posted as an officer in charge on our police station, and one Ashok Kumar who was there, he was demanded
The case of
30,000 rupees.
the case of Ashok Kumar is also listed today.
Yes.
We take it up together. You are the counsel there?
Both.
You are the counsel in that case also?
Yeah.
Take it serial number 1. 4. Serial 4 भी लीजिए सर.
Serial number 4.
Ashok Kumar had introduced you. Ashok Kumar had introduced Salesh Kumar.
No matter. He initially demanded for establishing a bakery in the village.
Ashok Kumar.
Ashok. Then he transferred there after immediately. I took the charge.
What is the date of transfer?
Transfer date is 18/1/2026. Date of transfer is only 18/1/2026.
18/1/26. And the date of allegation of demand is?
Demand is 16/1/2026.
16/1/26. Then he introduced, then Ashok Kumar
Yes,
introduced to Salesh Kumar.
yes, ma'am. And
What
date
is
of
that
trap is
Date of transfer.
20th of January 2026. 20,000, 30,000 demanded, but 20,000 was the trap money.
30,000 demanded, but it was agreed at 20,000.
20,000. But I am in custody since. Both of them are 20.
Charge sheet submitted?
Yes.
Charge plate?
No, no.
Both of them are custody since 22/1/26.
No. Ashok Kumar is custody since 22nd of January.
No, Ashok Kumar
Ashok
is
Kumar is from 20th. Sorry, I'm sorry. 2026.
Ashok Kumar is from 22, 126.
Ashok Kumar is from 20 to 2020. 21 to 2026.
No, 21 is Sailesh Kumar. Ashok Kumar is from?
He is
The Ashok Kumar is from 22 to 2026. 22 to 2026. Ashok Kumar. BA number.
no, his charge sheet has already been submitted.
Against both.
Both. And they obviously know they are in suspension.
You see, so far as Sailesh Kumar is concerned, he has been trapped. The money has been recovered from him. You can renew his prayer for bail after framing of charge. But so far as Ashok Kumar is concerned, I am granting.
After how many months?
Framing of charge.
After taking of charge. As you mentioned.
हो जाएगा ना? चार्ज फ्रेम हो जाने दीजिए. वो तो हो ही गया होगा मेरे ख्याल से.
नहीं चार्ज शीट ऐसे यूजुअली जो लोग का ये रहता है कि चार्ज शीट हो जाने के बाद because there is no tampering of evidence, no charge at all.
तो कस्टडी में बहुत कम है. आप इसमें थोड़ा तो कस्टडी में लीजिए.
अशोक कुमार का तो हो गया है.
अशोक कुमार, शैलेश कुमार का कस्टडी.
शैलेश कुमार का कस्टडी ज्यादा हो 22.
You see, Ashok Kumar, I grant him bail right. Okay. But so far as Sailesh Kumar is concerned,
After framing charge. After
framing charge का भी हो जाएगा.
नहीं अभी.
ठीक है, आपका framing.
framing charge जरूर दे.
इसको नहीं समझ आ रहा.
नहीं समझ गया तो. एज है एक्साइटेड होने का हम लोग नहीं.
देखिए अशोक कुमार. BA number 2710 of 2026. Heard the learned counsel appearing on behalf of the petitioner. The learned counsel for the petitioner submits that, as per the prosecution story, Ashok Kumar had demanded bribe money for the purpose of
ईटा बनाने का ब्रेक पिन होता है ना.
for the purpose of establishing a brick lane on 16/1/26, and immediately thereafter he was transferred. An order of transfer was issued on 18/1/26. The further case is that Ashok Kumar had introduced the co-accused Sailesh Kumar to the क्या नाम है इसका? Yes. Sailesh Kumar to the concerned person, and Sailesh Kumar demanded ₹30,000 but ultimately agreed on demand amount of ₹20,000, and Sailesh Kumar was trapped with that bribe money. The learned counsel submits that the charge sheet has already been submitted. He has further submitted that there is no allegation that the bribe money was collected by Sailesh Kumar on behalf of Ashok Kumar. ऐसा तो कोई allegation? The learned counsel for the state has opposed the prayer and has submitted that there is direct allegation against the petitioner. However, the bribe money was not recovered from the petitioner. Considering the aforesaid facts and circumstances and the fact that charge sheet has been submitted and he is in custody since 2026. The petitioner is directed to be in custody. BA number 1960 of 2026. The learned counsel, same story, right? The learned counsel for the petitioner has submitted that the petitioner is in custody since 22/1/2026 and charge sheet has already been submitted, but charge has not been framed. The learned counsel for the state has opposed the prayer and has submitted that there is direct allegation against the petitioner and he has been trapped with the bribe money. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is not inclined to enlarge the petitioner on bail at this stage. However, the petitioner may renew his prayer for bail after paying of charges.
Item 2, DA.22.16 of 2026.
Not a petitioner.
In this case, I let it.
The petitioner was a clerk. He was a minor education department. He demanded 8,000 rupees, but he was caught red-handed with 6,000 rupees. So he is a office of DU, not minor education. But he is in custody since 1812.
Just a moment, he is
For approval
petitioner
of
is
same.
as assistant in Samagra Shiksha Abhiyan. For approval of honorarium to the petitioner.
Yes.
Any antecedent?
No, I have stated in paragraph 30.
Custody?
Custody means 18/12/2015. 2015. 25, sorry.
25, 12, 15.
18/12.
25.
18, 12, 20.
18,
12,
18.
And what is the stage of the case?
The charge sheet has been submitted.
Charge free?
The charge can
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that, as per the allegation, the petitioner working as assistant in Samagra Shiksha Abhiyan, Jamtara, had demanded an amount of rupees 8,000 as bribe money for approval of honorarium from the complainant. However, only 6,000 was to be paid at the first instance and remaining after the work is done. The petitioner was caught red-handed with 6,000 rupees 6,000. The learned counsel submits that the petitioner is in custody since 28/12/2025 and charge sheet has been submitted but charge has not been filed so far. The learned counsel for the state has opposed the prayer and has submitted that the petitioner has been caught red-handed in a trap case and therefore the petitioner is not entitled to the privilege of bail. After hearing the learned counsel for the parties and considering the alleged facts and circumstances, this court is not inclined to enlarge the petitioner on bail at this stage. However, the petitioner may renew his prayer for bail after paying of charges.
Item 3, BA.23.05 of
In
2026.
these trivial amount involving trap cases, I have
No.
in these kind of trivial matters where small amount are involved in trap cases. Prima facie, I feel after framing of charge,
yes.
framing of charge के बाद
Yes.
second. वैसे punishment 7 years है कितना है?
जितना ट्रैप केस होता है,
हाँ.
I have an experience now. सबका कमिशन.
वैसे punishment prescribed कितना है? 7 years.
मतलब किसी का 3 साल.
Prescribed punishment कितना है? Maximum.
I just. 7 years.
7 years. एक बार चार्ज फ्रेम होने के बाद तो ट्रायल प्रोसीड कर जाता
हाँ, उसको तो ट्रायल में
है फिर तो ट्रायल प्रोसीड कर जाता है
कहीं
6 महीना के
भागने का
अंदर।
कुछ नहीं। No, but उनका सब गवर्नमेंट सर्वेंट है, they will join the office also, they will go to the particular.
अभी तो सस्पेंशन में होगा सर,
Pardon?
अभी कहाँ ऑफिस ज्वाइन करेंगे, दे मस्ट बी अंडर सस्पेंशन।
Yes, that's what.
ऑफिस कहाँ ज्वाइन करेंगे, खाली सब्सिस्टेंस अलाउंस।
48 hours custody के बाद ही तो सस्पेंशन।
And what is this?
No, it is a
Custody बताइए।
here it is 20,000
20,000।
and my lord, he is in custody since 15/2/26.
चार्ज शीट हो गया?
नहीं, चार्जशीट हो
चार्ज शीट।
कोई सेम ऑर्डर रहेगा।
हमको याद है कोर्ट नंबर 5। कोर्ट नंबर 5 में जैसे DN प्रसाद बैठते थे, PCR के केसेस में मी एंड मिस्टर कश्यप मेरे अपीयरिंग, और आपसे रोज लड़ाई होता था।
बीके को का साथ जो थे, उनका एक ही डायलॉग
कि बड़ा मछली को पकड़ो।
नहीं, बड़ा मछली को पकड़े, छोटा मछली को क्या पकड़े।
लेकिन उस समय बहुत WP क्रिमिनल फाइल होता था, क्योंकि चार्जशीट विद इन टाइम नहीं फाइल, सैंक्शन नहीं आता।
नहीं, सैंक्शन नहीं आता था।
मिस्टर कैरे थे वहाँ,
आज हम सबसे बात कर रहे थे।
एक में भी बेल नहीं मिलेगा।
नहीं, बेल नहीं मिलेगा। चारों केस मेरा ट्रैप केस है, लगातार 1 2 3 4। तो क्या बोलेंगे, खाली कस्टडी और अमाउंट चेंज कर देना।
सोचे होंगे कि बेल वेल नहीं मिलेगा।
नहीं, उससे कोई नहीं।
सच बोलिए सर।
सच बोल, so far me is concerned,
लोग एक ना एक लेडी जजेस के साथ एक क्वेश्चन मार्क लगा के ही रखते हैं, ये बेल नहीं देगी, ये इसमें रिलीफ नहीं देगी, पॉक्सो में रिलीफ नहीं देगी। तो ऐसा एक मतलब हमको लगता है कि ऐसा टेम्परामेंट सोच।
वकील लोग एवरेज देखता है कि पॉक्सो में कितना परसेंटेज है बेल मिलने का।
वो तो हम ये सी आई हैव माय सेट स्टैंडर्ड्स, दैट इज बेटर। जैसे कि हमको याद है DN प्रसाद के यहाँ नो TIP, नो रिकवरी इज अ गारंटीड बेल। हमको याद है ये सब चीज, he had his set standards।
वही 20,000 रुपया है कस्टडी
52। And what is the allegation?
allegation है, मतलब it was a minor immigration department that the project cost was 21,75,900.
For placing the case before the
They got that agreement to place before the executive engineer.
and he was the clerk.
At that time, he was
Senior clerk, because he is the senior clerk.
come cashier. Come cashier.
And the tender was already around.
That's-
Although the allegation was there.
That's my counter is it. And
The learned counsel for the state files counter affidavit in this case, which is taken on record. The learned counsel for the petitioner has submitted that the petitioner was the head clerk cum cashier in the office of minor litigation department, Gunda, and it is alleged that the estimated cost of project was ₹21,75,900, and he demanded a bribe of ₹20,000 to place it before the executive engineer. The learned counsel has submitted that the tender was already allocated in favor of the complainant.
Sorry to disturb. Till date, the sanction has not been accorded.
The learned
Cognizance been.
The learned counsel has submitted that the petitioner is in custody since 15/2/2026. Though the charge sheet has been submitted, but cognizance has not been taken. Charge sheet bhi nahi hua,
That's true.
but cognizance has not been taken for want of sanction or prosecution.
You must have been.
and also for want of FSL report. The learned counsel for the state has opposed the plea and they submitted that the petitioner has been caught red-handed with bribe money and therefore he may not be enlarged on bail. However, she has submitted that so far as point of sanction and FSL report is concerned, the state can take appropriate steps. आप उसको sanction जो करना है कर लीजिए. FSL report तो जब आएगा तब आएगा. FSL में बहुत टाइम. FSL में बहुत टाइम.
इसीलिए गवर्नमेंट ही सैंक्शन नहीं देते, गवर्नमेंट ही केस कर रहे हैं.
ये बहुत ज़्यादा सैंक्शन आ जाता है. एसीबी के पास में आ गया.
After hearing the learned counsel for the parties and considering the fact that the petitioner has been caught red-handed with bribe money, this court is not inclined to enlarge the petition on bail at this stage. However, the state is directed to expedite the matter regarding grant of sanction and also obtain the FSL report. The petitioner may renew his prayer for bail after 10 months.
इसमें जो 1 महीना 2 महीना कुछ कर देते हैं, सैंक्शन के चलते फिर चार्ज कर नहीं होगा.
ऐसे हो जाएगा.
The petitioner may renew his prayer for bail after 4 months. वो after 4 months भी नहीं.
Item 5 DA.29.05 of 2026.
तो release of salary.
Yes.
Salary release के लिए भी आपको पैसा मांगता है. हाँ?
4 महीने का रिलीज था उनका, इसके लिए मांग रहे थे 10,000.
कब से कस्टडी में?
Para 17 my lord, 2nd of February.
Charge sheet submitted when?
Para 12 of his petition my lords.
When has charge sheet been submitted?
Lords 11th of March 2026.
Cognizance taken? Cognizance हो गया? Or the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that the petitioner, that it is alleged that the petitioner the district IU's medical officer Tanva demanded a bribe money of ₹10,000 for releasing the salary every month of the complainant, who has been working as health officer under IU's community health center. He submits that the petitioner is alleged to have been apprehended red-handed with bribe money, and he is in custody since 2/2/2026. Charge sheet has been submitted on 11/3/2026. हर महीना आपको उनसे 10,000 रुपये चाहिए, नहीं?
सैलरी ऑलरेडी रिलीज था उनके लिए हो गया था.
Sorry?
4 महीने की सैलरी रिलीज हुआ था, पीरियड करना है 5,000 करना था. जिसके मांगे थे
He has submitted that. The loyal counsel for the state has opposed the prayer for bail. And has submitted that the petitioner has been caught red-handed with bribe money. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, who is said to have caught with bribe money, this court is not inclined to enlarge the petitioner further on bail at this stage. However, the petitioner may renew his prayer for bail after 6 months. Check in about it.
Item 6, DA.29.19 of 2026.
Sorry,
My company
मनरेगा का पैसा चाहिए.
is the Panchayat Secretary.
When is the petitioner? Petitioner is absent. Post on next Thursday.
Yes, I can.
Counter affidavit filed during the course of proceedings is taken on.
Item 7, DA.24.04 of 2026.
1031 of BS the petitioner is in custody since 6/8/2025. Allegation against the petitioner is that he has assaulted his wife, and which constitutes the death of the deceased person. In this case, a charge sheet has been filed, and the charge is also failed.
Train item 103(1). You are the sole accused.
Yes, ma'am.
For the learned counsel appearing on behalf of the parties.
There is no eyewitness and there is no crime for the document.
The learned counsel for the petitioner has submitted that the petitioner is the husband of the deceased, and the deceased was found dead in a matrimonial home. He submits that there is no allegation of demand of any dowry, and it is alleged that the husband has been assaulting the victim, which became the cause of death. The learned counsel for the state has opposed the prayer and has submitted that the petitioner may not be released on bail. After hearing the learned counsel for the parties and considering the fact that the victim died in a matrimonial home within 5 years of marriage, and there is direct allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail constituted.
Item 8, DA.3414 of 2026.
Victim is the wife of this.
Yes.
The father has lost the case. That the petitioner enticed her daughter to live. And there they resided together for about 8 months.
What is the age of the victim? Age.
17. And the marriage was solemnized with the consent of both the families. Both the families.
The
Once the
state is directed to serve notice to the victim
at
and
least
sign an
the
affidavit regarding service of
a
notice.
point is required to the consider.
अभी victim को सुन के आपका शादी हो गया, आपके साथ रहना चाहती है तो भेज देंगे ना, फिर आपको भेज देंगे. Let her come and say that she wants to live.
Provision of Child Marriage Act का केस बनेगा.
CBM 160
ऐसा नहीं है.
है.
ऐसा नहीं है. You enticed away, took her to
After
Delhi.
marriage.
Not after marriage.
Yes.
You married later on.
No. That is in the FIR. After marriage. And this is also in the impugn order.
Victim आपके साथ रहना चाह रही होगी ना?
हम नहीं
Notice
नहीं
कर-
मार करना चाहते.
Notice करते हैं इसको.
The husband sees my wife.
The counsel for the state is directed to serve notice to the victim and also file a counter affidavit in this case. Sorry,
183
I think
वो सब आ जाए. The case diary along with the statement of the victim recorded under section 183 BNSS
Yes, ma'am.
and her medical examination report
no mention.
along with her details regarding her age, We call for from the consent.
Age कुछ भी हो now she is
Post on 13th of May.
age whatever will be age, but the consent of both the families, the marriage was like discussed.
Let us see in the case study. It is all looking out. The learned counsel for the petitioner has submitted that with the consent of both the families, the petitioner got married with the victim and it has come in the case study. देख लेंगे भाई.
And that is also the
Under reading for admission, item 9, ABA 7348 of 2023.
9 and 10 the same.
9 and 10 दोनों केस.
Oh,
9 and
10.
10. ये 9 है.
ये नहीं.
I think
This
there
is
are more
cheat
cases.
cheat fund matters.
और भी matters.
एक का तो रिजेक्ट हो चुका है.
हाँ, एक का तो reject हो गया.
This is
You
direct.
see, you had no license to work in state of Jharkhand. Why did you extend your operation in the state of Jharkhand? Who are you? Let us see what is your standing.
But here what the amount involved is only 8 lakhs.
It's not a matter of amount involved. It's a matter of so many people involved and how a company is operating.
Now they are not operating. A lot when the PI was there, lot of having more than 100 this. And I am only relying on the Supreme Court judges in those matters where we participated in the investigation till the charge sheet was submitted.
What is the maximum punishment here?
409
409 is 10 years, no?
Life in prison.
It was to 9.
Life. Oh, yes. तो उसमें कैसे ये judgment उसमें?
नहीं वो जजमेंट नहीं है ये वो जजमेंट नहीं है एक बार देख लो बस मेरा संतुष्ट है ये मीना इसका सब इसको
Which paragraph are you in?
9 to 13 first minute
Please read.
Siddharth
Read it, please.
well I'll read it 9 we are the agreement with the appropriate view of the High Court and I would like to give an imperative to the state judicial view. It has rightly been observed in consideration of Section 170 CRPC. It does not impose an obligation on the officer in charge to arrest each and every accused at the time of finding of charge sheet. We have in fact come across cases where the accused has cooperated in the investigation throughout, yet and the charge sheet being filed, non-bailable warrants have been issued for this production, premised on the requirement that there is an obligation to arrest the accused and produce him to the court. We are of the view that if the investigation officer does not believe that the accused will be abscond or disobey summons, or he or she is not required to produce in custody. The word custody appearing in section 170 CRPC does not contemplate either police or judicial custody, but it is merely connotes the presentation of the accused by the investigating officer to the court while finding out the charge. We may know that the personal liberty is an important aspect of our constitutional mandate. The occasion to arrest an accused during investigation arises when custodial investigation becomes a necessary or is heinous crime, or there is a possibility of influencing the witnesses or accused may abscond. Merely because an arrest can be made, because it is a lawful, does not mandate the arrest must be made. The distinction must be made between the existence of the power to arrest and the justification for exercise of it. If arrest is made routine, it can cause incalculable harm for the reputation and safety of a person. If the investigation officer has no reason to believe that the accused will abscond or obey summons, and he is in fact throughout cooperate with the investigation, we fail to appreciate why there should be a concern on the officer to the We are in fact face the situation where, contrary to the observation in Vindar Kumar case, our police officer to deal with the scenario of arrest. The trial courts are stated to be insisting on the arrest of an accused or prerequisite formality to take charge on record in view of the provisions of section 176. We consider such a course of in place as contrary to the very intent of section 176. In the present case, your lordship must be faster than me. And the second judgment also I have given.
The co-accused may have also been what you just did.
Nothing more than
On this judgment, shape.
No, this is a different judgment. It is
this is
whether he should be arrested at the stage of
That until
charge
says,
sheet.
that for this category, until judgment says category B and D, it will fall in D. On appearance, accused in court pursuant to process issued bail application to be decided on merits. Now here it is a charge sheet of 19. He has to also show what is his apprehension. The case is running at the stage of appearance. Cognizance was taken in 19 itself, 11/11/19. So
Cognizance has been taken on 11/11/19.
11/19, charge sheet was submitted in 19. Therefore, on 11th November, the cognizance was taken. Then he filed his bail application, which was dismissed for non-prosecution in 23.
That's
Now he renews the apprehension. He has to show what is the apprehension. And until says in this kind of serious economic offences, on summon he should go and appear, and his bail petition will be decided on merit. It is not a case of anticipatory bail. That is the categories. If I just place, I am having that soft copy for revision.
another one paragraph.
So, and co-accused bail is rejected. So, where the co-accused was also director, as he is in 9, he is the director. In 10, he is the beneficiary.
he is the director.
He is the director. Yes, he is the director. In 10, in one company he is director, in one company he is beneficiary. Vice
This petitioner in ABS 7348 is
director.
director.
Director. There are 3 companies involved in the issue of instruction. 2 companies director and 1 company he is vice chair.
In 2 company he is director.
Director and 1 company is vice chair.
That is in page 104. Okay. And the next case is on
Just that is for you. Heard the learned counsel's opinion on behalf of the parties. The learned counsel for the petitioner has submitted that though the petitioner is director in 2 companies and vice president in 1 company involved in the present case, but there is no need for any custodial interrogation of the petitioner. He has further submitted that under such circumstances the petitioner is entitled to anticipatory bail. The learned counsel for the opposite party has objected to the prayer for bail and has submitted that cognizance was taken as back as on 11/11/2019. And since then, the petitioner has not appeared before the court.
The stage of the case is for appearance.
And the stage of the case is for appearance of the petitioner. He submits that it is very clear that the petitioner is evading his appearance and arrest. वारंट ऑफ अरेस्ट तो इशू हो गया होगा इनका, नहीं पता.
नहीं इशू नहीं.
अच्छा, he is avoiding appearance before that. The learned counsel submits that it's a serious economic offence and if he appears before the court, his bail application, surrender cum bail application can be considered as per law. The punishment prescribed for the alleged offence is life. Life imprisonment.
Life. 409 life imprisonment.
Maximum punishment.
Maximum.
And there are materials against the petitioner. He does not deserve anticipatory bail.
Wait.
He has also submitted that the anticipatory bail of the accused, namely Aliul Islam, has been rejected by the order dated 5th of July 2024 in APA number 8810/2023. After hearing the learned counsel for the parties, it has been alleged, this court finds that it is alleged that the petitioner is director of 2 companies. क्या नाम है उसका? एक सक्सेस
वैली इंडिया एग्रो लिमिटेड,
एक सक्सेस वैली इंडिया एग्रो लिमिटेड, दूसरा
सक्सेस वैली प्रोजेक्ट्स.
सक्सेस वैली प्रोजेक्ट्स,
This is two companies where the petitioner is the
where the
director.
petitioner is the director
Your petition will find from page 90.
and is
Third company is the vice president of Success Valley Credit Cooperative Society.
he is the vice president of Success Valley Trading Cooperative Society. Page number?
Internal page 20 of the charge sheet. Here it will be in this
Page number?
91.
Page 91 will be the
16. Yes.
It has
87 and 91.
It has been alleged that the company had cheated large number of persons and has operated within the state of Jharkhand, although they were entitled to carry out their activity in the state of Delhi and West Bengal. In view of the nature of allegation involved in this case, and that several investors investing amount on inducement of the accused persons, and consequently they have been treated with respect to huge amount of money. This court is of the view that the petition is not entitled to grant of anticipatory bail. The fact remains that similarly situated co-accused, namely Aliul Alam, his prayer for bail has been rejected by court of justice.
Page 16, 19 and 26. Company details there.
Page 16, 19 and 26. इसका क्या है?
He is managing director come vice chair.
Managing director
Yes.
of one company, Success Valley Credit Cooperative Society.
Managing director,
President come managing director.
president cum managing director of Success Valley
Credit Cooperative Society Limited. Page
Credit
90.
Cooperative Society Limited.
90.
Same order?
Obliged.
Item 11, ABS 6455 of 2025.
With respect to this case, the petitioner and the husband reached Supreme Court wherein the petitioner has received no coercive orders subject to coordination and investigation, and petitioner has started cooperating with investigation.
So this anticipatory bail has become in practice.
Yes.
The learned counsel for the petitioner submits that this anticipatory bail has become in practice, and therefore she does not want to place this in it. This anticipatory bail is dismissed as in practice.
साइन कर दीजिए
State that bail is
आइटम 12 ABS 7079 of 2025
इसी FIR से 2-3 केसेस हैं.
पाँच छह केस है
5-6 केस हैं.
Serial number 12 and 14 are absolutely similar. One is circle inspector, another is circle sub inspector or revenue collector.
That's right.
And then other cases, but 17 is similar, 20 is similar, but though are similar, I'll point it out.
कोर्ट यूज का बिल एंटीसिपेटरी तो सबका
सबका रिजेक्ट हो गया था, एक का रेगुलर बिल रिजेक्ट हुआ था, जिसको सुप्रीम कोर्ट ने रेगुलर बिल दिया है.
बट एंटीसिपेटरी बिल स्टैंड्स. नेक्स्ट केस का नहीं, एक के बाद एक सब खोल दो.
आइटम 12 7079 of 2025 आइटम 13 ABA 7264 of 2025
ये भी उसी से
नहीं, this is another FIR, bro. This is in Hazaribagh, but this is in respect of a land belonging to.
That's right.
And bro, his
Yeah,
brother.
Vinay Chaubey is also there.
No, yes, Vinay Chaubey is also there.
Yes.
In fact, bro, everything is
एंटीसिपेटरी बिल तो कोर्ट यूज का रिजेक्ट
reject है और उनका उनके ब्रदर हैं और ये लोग they are not identifying, not their address is correct in the Aadhaar, sorry, in the petition filed before the court. At no stage they are, in fact, इन्हीं के कारण जो है हम लोग का काफी इन्वेस्टिगेशन हुआ.
This is my senior decision with passport.
पास ओवर कल आ जाए.
Yes.
ठीक है.
आइटम 14 ABA 270 of 2026 आइटम 15 ABA 370 of 2026
Not today.
Morning.
Yeah, file it. The learned counsel for the petitioner seeks adjournment. The learned counsel for the state is directed to file a counter affidavit in this case. Post this case on 14th of May. 14th May. The counter affidavit इसके पहले कर देंगे फाइल, right? Counter affidavit be filed by 12th.
आइटम 16 ABA 917 of 2026
Case administration for the 6 and 31 year PC Act. Basic prosecution is that of प्रधानमंत्री ग्रामीण सड़क योजना promoted to lower the lordship resulted in mistake. There was a tender and tender was awarded to the local construction notice. In this case, agreement amount is 90 lakhs. The local construction allegation he executed the work of 44 lakhs. Excess payment that was alleged by the prosecution 46 lakhs. Now in this case, lordship, the husband of the petitioner, Mutation Prasad, will the provider of the form lordship, is a named accused in this case. Now otherwise, lordship, she is not named in the file lordship. Rather, he or she has been made as a partner in order to save the income tax lordship.
That's right. What is your explanation? What is your explanation? You have purchased property in the name of your wife?
नहीं ये तो किस नहीं
are not a government servant.
नहीं, हम गवर्नमेंट से हम कॉन्ट्रैक्टर होते, मेरे हस्बैंड ने लोटस कंस्ट्रक्शन फर्म में ठेका लिया था और उन्होंने 90 लाख का एग्रीमेंट था और 44 लाख का काम की एलिगेशन है और 46 लाख का एक्सेस पेमेंट है और इसमें जिस आधार पर टेंडर करा जिस डील जो पार्टनरशिप डील हुई जिस आधार पर मुझे टेंडर पर ये काम दिया गया था वो मैंने लगाया हूँ.
How are you coming in?
हम
How are you coming in?
अच्छा इसमें मैं चार्जशीट एज ओनली एविडेंस है कि मुझे चार्जशीट सबमिट कर दिया गया एज ए पार्टनर.
Oh, you are the partner of the firm.
हाँ चार्जशीट
कौन है क्या? What do you mean? You are a partner of the firm?
मेरा स्टेटस गवर्नमेंट स्लीपिंग पार्टनर.
Dormant sleeping partner कुछ नहीं होता. What do you mean dormant sleeping partner? Because you are a lady, you are a dormant sleeping partner.
चार्जशीट we submit in that I have not been arrested or
कोई बात नहीं. You are not entitled to anticipatory bail. You are a partner. Not a case for anticipatory. AD number 917 of.
we Satinder did I may be like to surrender or in this case.
You withdraw and surrender. You withdraw and surrender.
सतेंद्र ने तो नहीं होगा.
हम नहीं जानते क्या हुआ. इनको मन है तो जाके अपना सरेंडर करके आपको जो मर्जी हो वहाँ करिए. इसमें तो कुछ बोल नहीं सकते. क्या करना है?
एक पैकेज है उसमें एक किसी में टेंडर में एक केस में मेरे को ऑन सरेंडर ऑन द
कोई ऑब्जर्वेशन हम नहीं. आपको विड्रॉ करना है विड्रॉ करिए. आपको जो मन हो. नहीं तो हम तो रिजेक्ट करते हैं.
अच्छा विड्रॉ
Counsel for the petitioner seeks permission to withdraw this anticipatory bail application, which is dismissed as withdrawn.
साइन कर दीजिए.
आपके सब arguments लिखने
Item 17.
You have to put your signature, Counsel. Put your signature.
Item 17 DA 927.
Brief was not passed.
Item 18 AGA 932/2026.
Awesome.
Item 19 BA 1080/2026.
Under section 420, 467, 468, 471, 120. And on read with 13 to read with 13(1)(d). Now, if your Ashkan is looking at the FIR,
Possible to 17, possible 19 है 20 23
Click on sir.
19.
These are one of those cases which are to be taken up together.
No, but of course, this is an ACB, this is ACB 11, but already.
But every case has its own facts.
Fact.
That's
Can be
it.
taken
You can
up.
start with this.
Yes, we can start.
Okay, and then we'll have one after another.
Yes.
subject to correction of my learned friend here, the FIR, the written report starts at page 39.
Page 39.
छोटा अलग अलग इसीलिए नहीं वापस कभी पढ़ी.
Yes, it starts at page 39.
Page 39. Now, P was registered in the year 2015, and this FIR was registered in 2025. P 24 of 15, dated 17/8/2015. After 10 years, this FIR was registered.
Please read it.
Yes. Now, the first part is not concerning me. That's not page 40 where I am concerned.
read the introductory part and then we'll come.
Okay.
Yes, please read it. मैं आप अपने आप पढ़िए ना सर कितना परेशान पढ़िए.
मैं स्वयं सो नागपुर जिला रांची के निवासी हूँ. वर्तमान में पुलिस परीक्षक का कार्य प्रभारी भ्रष्टाचार विरोध थाना हजारीबाग के पद पर बदली. आज दिनांक 25/9/25 को समय 7 बजे अपना लिखित बयान दर्ज करता हूँ. आवेदक त्रिपुरारी सिंह पत्रकार सचिव पत्रकार संघ कर्म हजारीबाग के द्वारा माननीय मुख्यमंत्री झारखंड सरकार को इस आशय का शिकायत आवेदन दिया गया था. हजारीबाग जिला के अंतर्गत उद्यान की जमीन, वन भूमि, सरकारी जमीन, पंचायती जमीन एवं गैर उद्योग आम व खास जमीन को भू माफिया द्वारा अवैध तरीके से हासिल किया जा रहा है, जिसके आरोप में निगरानी ब्यूरो जांच संख्या 24/15 दिनांक 27/8/15 दर्ज कर जांच किया जा रहा है.
Now let us see the allegation against you.
Yes.
कौन सा पेज नंबर?
Page 14. थर्ड पैराग्राफ. इसके अतिरिक्त जांच के दौरान
इसके अतिरिक्त जांच. यस.
इसके अतिरिक्त जांच के दौरान मौजा बनवे थाना संख्या 252 के अंतर्गत खाता संख्या 95 प्लॉट संख्या 848 रकबा 28 डिसमिल, खाता संख्या 73 प्लॉट संख्या 812 रकबा 72 डिसमिल, कुल रकबा 1 एकड़ भूमि विनय कुमार सिंह पिता सुवंशु एवं श्रीमती स्मिता सिंह पत्नी सुवंशु को दस्तावेज संख्या 1710 दिनांक 10/2/2010 द्वारा खरीदी से हासिल है. इस डीड के अनुसार विक्रेता भगवान प्रसाद गुप्ता, ईश्वर दयाल गुप्ता दोनों पिता सचिन सच, सत्यनारायण गुप्ता, प्रसाद गुप्ता दोनों पिता सचिन सच, प्रेम कुमार गुप्ता, रामकृष्ण गुप्ता, रामकिशोर गुप्ता, रमापति गुप्ता, बलवंत गुप्ता द्वारा अटर्नी होल्डर दानिंद्र कुमार पिता सुरेंद्र, देन पाल गोविंद साहू, अमृत कुमार, किशोर प्रसाद द्वारा और अटर्नी होल्डर श्री निरंजन कुमार पिता सचिन सच हजारीबाग है. इसका नामांतरण दाखिल खारिज वाद संख्या 481/2010/11 दिनांक 18/8/2010 को निष्पादित हुआ है. उल्लेखनीय है कि कार्यालय अंचल अधिकारी हजारीबाग सदर का पत्रांक 11/77 दिनांक 18/6/25 द्वारा जांचकर्ता को जानकारी साझा किया गया कि खाता संख्या 73 प्लॉट संख्या 812 कुल रकबा 76.76 एकड़ किस्म टाड़ रैयती खाते की भूमि है, जिसका खतियानी रैयत प्रसाद भूमिया दर्ज है. इस भूमि के दाखिल खारिज में कोई आपत्ति नहीं है क्योंकि यह रैयती भूमि है. खाता संख्या 95 प्लॉट संख्या 848 गैर मुजरमा खाते की भूमि है, जिसका किस्म जंगल. इस भूखंड के दाखिल खारिज पर आपत्ति है क्योंकि यह गैर मुजरमा खास किसी जंगल भूमि है तथा इसका गैर वानिकी कार्य हेतु उपयोग माननीय सर्वोच्च न्यायालय के द्वारा रेट संख्या 3 गोवर्धन बनाम भारत सरकार में पारित आदेश दिनांक 12/12/96 का उल्लंघन है. इसी खाता 95 और प्लॉट संख्या 848 से 28 डिसमिल जमीन विनय कुमार सिंह पिता सुरंसो एवं स्मिता सिंह सुरंसो द्वारा क्रय किया गया तथा दाखिल खारिज भी किया गया, जबकि इसी तरह की जमाबंदी को गलत माना गया है और जमाबंदी रद्द की गई है. अतः स्पष्ट है कि क्रेता विनय सिंह पिता सुरंसो एवं स्मिता सिंह सुरंसो इतना भूमि का गलत तरीके से जमाबंदी किया गया है. इस अवैध जमाबंदी को तत्कालीन राजस्व कर्मचारी संतोष कुमार वर्मा, तत्कालीन अंचल निरीक्षक राजेंद्र प्रसाद सिंह एवं तत्कालीन अंचल अधिकारी अलका कुमारी द्वारा 18/8/2010 को किया गया. प्रारंभिक जांच के क्रम में स्थापित हुआ है कि उक्त पदाधिकारी कर्मी द्वारा पद को दुरुपयोग करते हुए क्रेता एवं विक्रेता में आपस में षड्यंत्र कर सदोष लाभ प्राप्त करने के उद्देश्य तथा सरकार को हानि पहुंचाने की नीयत से अपराध कारित किया गया. This is the fact. Petitioner is not named.
What is the petitioner?
What is the name of the petitioner?
Vinay Kumar Chowk.
So petitioner is not named.
No.
No.
So what is the material against him?
Yes. Now you lordship will find in the accused column.
This is the only allegation.
This is
The
the
entire
case.
FIR.
This is the case in the FIR.
Yes, there is a case in there. Alka Kumari, one of the accused, is number 2. After such a long period, when the FIR was made, she made a 164 statement that I verbally told her, Vinay Kumar Singh, और उनकी उसकी वाइफ के नाम पर आप म्यूटेशन कर. This is the so for the main part of the allegation is this.
164 statement or
183
183 minutes.
yes, Alka Kumari, the circle officer who has passed the order of mutation.
So, what was the position you were holding at that point of time?
I'm the Deputy Commissioner Hazari.
Since when are you in custody?
Pardon?
Since when are you in custody in
Since
relation with this case?
11/11/25.
11/11/24. Charge sheet, submitted,
Charge sheet.
charge framed, everything done.
The charge sheet. ये बहुत accused है ना जो सरकार भी. Only one thing I must make it clear. But against me, first one of the state ACB department came with that liquor scam.
विक्टिमाइजेशन का बात मत करिए, इससे कुछ होगा नहीं।
हाँ.
सबसे कुछ नहीं होने वाला। But the only link in this case, so far as you are concerned, is
That
the statement recorded under section 164 of CRPC by the circle.
It is I commanded her to उसका नाम पर mutation.
That is all.
That is the some of the impede on
And what? Why are there so many accused persons?
जितना big chunk of land. The revenue officers came and gone, power of attorney holders, sale and purchase.
And Alka Kumari is the person who has been doing the mutation in all the cases?
No, in respect of Vinay Kumar.
Only in respect of Vinay Kumar. There must be other
Yes,
deputy
yes,
commissioners
yes,
also,
yes,
or
yes.
other deputy commissioners from time to time are
Yes,
also
yes.
accused. Other deputy commissioners.
Yes, obviously, नहीं. Only I have been detected.
Only you have been accused. Is that the only allegation against the respondent?
In the
Is that
FIR,
the only
in the
allegation
FIR.
against the petitioner in the FIR? On the basis of statement under section 164?
Not only with respect to statement under section 164, there are the other accused persons during investigation have also stated that he had pressurized with respect to doing this mutation in question. And further, the mutation records are missing. I have a lot of materials, if I'll take.
You see, if he was a deputy commissioner.
Yes.
If the mutation records are missing, he has no role to play in that. Or he also has a role to play in.
But in fact, this particular, this is a land scam. If you watch the other part of the FIR when I showed you, relevant part of time, he was also the deputy commissioner in that those land scams as well. But we have not got any direct evidence so far as his involvement with respect to the mutation and other things are being done. So we have not as yet, to that extent, we are not alleging against him. But where his direct involvement has come with respect to this 28 decimals of land, that Malord we have brought on record by virtue of our investigation when it revealed to us. If you see her leadership in the FIR, he was not made as an accused because we were making an investigation with respect to the land scam. And
so he is in custody merely on the basis of a statement of a circle officer that he has done this work at the instance of this petitioner.
Not merely on the basis of the circle.
What other material are there against?
Correct. The other materials is one that the circle officer has given the statement.
That's right.
The revenue inspector has given the same statement that he was called before in the office of the deputy commissioner and he was pressurized. Then we have collected evidences where we have link of money between the petitioner and the person to whom he had benefited by virtue of the transaction.
Where is that?
Yes, kindly see that. Kindly, may I just show, first may I show the statement, two statements, yes. And then, may I kindly see para 17 of my counter. I just prepared for the leadership read manual. Other side.
Can I finish up my argument?
Because you said that this is the only argument that
there subsequently what my learned friend is going to say.
Let him complete. Let him complete.
Right.
You know what he is going to say.
Yeah.
Yes. You complete your argument. You complete your argument. I am hearing you. No, it can't be like this. You complete your argument, he will respond to you. Because that was the only allegation you told me that this is the only allegation.
This is over the FIR is concerned.
Okay. Just a moment. One second. Just a moment. The learned counsel for the petitioner has submitted that the preliminary inquiry in this case was instituted by PE number 24 of 2015 as back as on 17/8/2015, and FIR was lodged after almost 10 years on 25/9/2015. He has further submitted that though the petitioner is not named in the FIR, but from the FIR the only portion which links the petitioner is in connection with certain inquiry whereby Vinay Kumar Singh and Srimati Snigdha Singh had purchased the property and their name was mutated in mutation case number 481 of 2010-11, and it was alleged that a portion of the property in khata number 95 plot number 848 was Gair Majurwa land having the nature jungle. He submits that in the FIR itself it has been mentioned that previously the mutation of forest land was done and the mutation was also cancelled, but so far as this property is concerned, the mutation was done in favor of Vinay Kumar Singh and Snigdha Singh. He has further submitted that the circle officer, the then circle officer was one Alka Kumari. He submits that Srimati Alka Kumari had made a statement under section 183 BNSS before the court that the mutation was done at the instructions of the present petitioner who was the then Deputy Commissioner Hazaribagh. Chaliye, आगे.
Your Worship may turn to page 79. The MP note. Your Worship, they are showing the connivance. In order to show the connivance of the petitioner with the co-accused Vinay Kumar Singh and Snigdha Singh, it is submitted that during investigation of the same case, financial transactions between them to large scale were detected. And for just saying that it is submitted that during the period from 1/3/2010 to 9/7/2015, a total sum of rupees 3.16 crore in cash were deposited in the bank account of the company whose directors are wife and brother-in-law of the present petitioner. It is submitted that during the year 2019 to 2023, those several transactions of 72 lakhs and all were transferred from the companies owned by accused Vinay Kumar Singh and Snigdha Singh to the wife of the petitioner. In the year 2023, an account of 14 lakhs and all is stated to be transferred from the account of co-accused Snigdha Singh, Priyanka Trivedi and Siraj Trivedi, who is stated to be related to the present petitioner. Further, two debit entries, the transactions of 2,50,000 and 76,000 are stated to be made on the account of Srivil Trivedi and on the account of owned by co-accused Vinay Kumar Singh and Snigdha Singh. This is the only part of allegation that why my connivance, I said it at the time of that mutation. Now after 10 years, this has been done. Now your Lordship can have a look into my reply. Perhaps 4 to para 7 of the first supplement.
Yes, para 4 to 7.
7. That number Roman 100. It is alleged that during the period 3/3/2010 to 9/7/2015, a sum of rupees 3.16 crores by way of cash were deposited in the bank account of the company owned by the wife and the brother-in-law of the petitioner, namely Brahmastra Education Private Limited. In regard to the said allegation, it is stated that the Sapna Sanchita, who happens to be the wife of the petitioner, is a B.Tech graduate and an IIM alumnus and a highly qualified lady in running the said institutions since 2006. The said transaction is the franchise of institution is the franchise of time, and they are providing education, coaching relations to CAT and other MBA entrance examination, IPMAT, CLAT, and grant provision officer, etc. The said Brahmastra Education Private Limited has trained more than 5,000 students in the last 20 years, and every money earned by the BEPM is fully accounted, and in the 4 financial years, audit is being done by the company. It is relevant to point out that here that during the period of 2010 to 2015, online payments were not prevalent and tuition fees were being deposited by way of cash or check. Furthermore, petitioner has to no concern with the said institution done by the wife and no connection with the said transaction. We will annex that bullet. Thereafter, bullet 5. The petitioner states that and submits that it is alleged that during the year 2019 to 2023, several transactions amounting to rupees 72 lakhs and odd were made from the company owned by Vinay Kumar Singh in the account of the wife of the petitioner. In regard to the said allegation, it is stated that apart from the said institution, the Sapna Sanchita is also engaged in providing consultancy service, and since 2019 to 2023, she has provided legitimate consulting services to Next-Gen Technological Solution owned by co-equals Vinay Kumar Singh, and she has paid monthly remuneration of 1.50 lakh, and the said amount was paid after deduction of TDS and wages reflected in the form 26As. Now, paragraph 6. The petitioner states and submits that it is further alleged that on account of rupees 14 lakhs and odd was being transferred from the account of co-equals Snigdha Singh is the amount of Priyanka Trivedi and Sivraj Trivedi, who are the sister-in-law and brother-in-law of the petitioner. In connection with the alleged transaction, it is stated that Priyanka Trivedi has sold one property to Snigdha Singh by virtue of his registered sale deed, and same amount was paid to part consideration to the said property. More so, petitioner has no concern at all with the said transaction. The petitioner states and submits that it is also alleged that there was some financial transaction from the account of Sivraj Trivedi to the account of company owned by the acquirant Vinay Singh. In regard to the said transaction, it is stated that Sivraj Trivedi has purchased a car, Nexus Solution Technologies, and the said amount was paid to purchasing the state. These are the last submission.
Excellent. The learned counsel for the petition has referred to the improved order at internal page 4, and has submitted that the money transaction with respect to the petitioner, with respect to the wife of the petitioner and family members, and Vinay Kumar Singh and Stigna Singh has been mentioned therein. With respect to each transaction, the petitioner has filed supplementary affidavit, and the explanation has been furnished right from paragraph 4 to 7 of the supplementary affidavit.
Now, there was a case from the land is concerned, a Khas property, in which I was made an accused. Vinay Kumar Singh was also making it. Their bill of treatment was rejected here. The Honorable Supreme Court in Vinay Kumar Singh's case, first rejected. That is in the first supplementary.
That is in another case. Khas
The
nahi.
present case is as well as the score related. This part which I read it out, they took that ground also.
Maybe whatever. That is a separate FIR.
No. Present case.
You moved the Honorable Supreme Court for your regular bail also in this case.
This is only regular. I have been
In this
asking-
case, there are multiple cases against you. For each case, you are moving your antecedent.
No, I am saying that I am not clear to you, Lordship. So far as the allegation of 3,16 crores, 3.6, that has been taken in that case also. That has been made common in all cases. Now what Vinay Kumar Singh has been granted bail in this case by the Honorable Supreme. Now I am referring to that order.
Where is that?
Now that is rejoinder dated 16/3/2026, annexure 1 when it starts.
Yes.
I'll state me your lordship, invite your lordship to page 25 of that order.
It was a petition filed under 32.
No, there are read, all matters are happening.
You are referring to page number
25, 9 page.
25. Yes.
Very good. Paragraph 9. At the outset, it requires to be noticed that petition number 1 was called for the SCB Ranchi in a FIR number such and such for the purpose of investigation. By taking up an investigation on the same day, FIR 11, the present case, 11 is the present case, came to the register by the SCB Hazaribagh for the offences punishable referred to the herein supra, namely pertaining to alleged mutation of forest land in the name of petition number 1 and 2 in the year 2010 with alleged connivance of the government officials. Though it is very intriguing to know that mutation entry having taken place in the year 2010 with approval of the hierarchy of the revenue officials gave the 15 years. They did not pursue the matter. Only in the year 2026, the said FIR has been registered. We do not propose to go into the correctness or otherwise of the said registration of the FIR at this stage. It is likely to prejudice the rights of the parties we live at. The court, while entertaining the prayer for grant of bail, especially a petition criminal, wherein the bail which has to be refused by the Jharkhand High Court in Vietnam has granted interim bail on such and such. It is further intriguing against we notice that while submissions were being made before the court on such and such day, there was not even a whisper with regard to the FIR number 20 or 25 and FIR number 28 or 25.
This 20 or 25 is different.
Different.
Another case.
Just after this. I am also an accused. I was. Paragraph 12. Paragraph 12. In the instant case, this court is fully satisfied. The successive registration of FIR to ensure to keep the petition number 1 within the custody. Now here I am also. And we are also forfeited to the fact that the grant of bail by this court on 7/25 petition number 1 was remanded to custodial interrogation by an order dated 19/12 passed by the judicial magistrate in the FIR number such as. Again, further remand was granted for 7 days as against the prayer of the 14 days by the order dated such and such in the FIR number 20. By the judicial magistrate, this continued and conduct of the prosecution will clearly establish the respondents have consciously ensured that the petitioner is placed in custody. The same is here in my case also, madam. That's why at the very outset I said, madam,
So you have been granted in FIR number 20 of 25, registered on 25/11.
but I was
FIR
not-
number 458, registered on 26/11.
This is request register.
And he not being an accused in FIR number 9. This is FIR number
11.
11.
He was also 9 also he was an accused.
No, but it has, and he not being an accused in FIR number 9, registered on 25/25.
He denies.
Yes, he has been granted anticipatory bail by the jurisdiction court. So for the same transaction, you want to say that
I was also made an accused. One case was granted bail, default bail. Next day I have been taken into custody. In one of that
liquor scam you were granted.
that was. Thereafter one of that 9 of 25. In that case my bail application was rejected.
So this present petitioner, for the same transaction relating to the same mutation, is an accused in all these cases. He is not an accused in all these cases. But of course, Binay Kumar Singh was accused in all these cases. Which the Honorable Supreme Court has taken note of, that in relation to the same kind of transaction, rather, multiple cases have been registered. For you also, with respect to the same transaction, multiple cases have been registered.
2 cases.
2 cases. One is this one, and the other is
9 of 26.
9 of 20. In that you have been granted default bail.
By Supreme.
You have been granted bail by Supreme. 9 of 20.
9.
Where is that bail order?
We have not on record. 21/4/26. Annexure 2 at page 7. This is in respect of transfer of Khasman property.
This is not the property involved in this case is not Khasmal property.
No, it is a forest.
It's a forest land.
Yes.
So you want to say that this 9 of 25 is also in relation to the same forest land?
No.
No.
Khasman.
So these are 2 different transactions.
I am saying that when I have been kept in custody, in one case I have been granted bail, again next day I have been in money.
Naturally, when there is some transaction and something comes up, you will become accused
And the
in
same
multiple
transaction we
transactions.
have edited now, in explanation is given in page paragraph 4 to paragraph 7. That was also here. Same. Amount is same, everything is.
Yes, what do you want to place from this?
Only 100 bail.
We therefore allow the appeal. The appellant shall be produced before the concerned trial court as early as possible, and the trial court shall release him on bail subject to condition as he may deem fit.
One of the circle officer of the present case, this case, has also been granted bail by Honorable Supreme Court, that is action 1 at page 6. Of the same circle.
The circle officer, this Kumari, has been granted bail,
No, Salish.
with which you are not concerned.
No, I'm not concerned.
You are not concerned with Salish.
And Alka Kumari has not been arrested also. Because she has given a statement against me, which the government wanted. After 10 years. Now they are not sure whether she will be accused or not.
Right. Actually, she is giving a statement against herself.
She has given, but that's what. She is not on bail, neither she has been arrested, nothing.
That's all. Okay. The learned counsel has submitted that the co-accused Vinay Kumar Singh has been granted bail by the Honorable Supreme Court. In connection with FIR number 20 of 25 registered on 24/11/25.
Not 20. In connection with the present case.
Sorry,
In connection with the present case.
ये कौन सा केस नंबर है?
11 of 25. If you also come to case 29, there are composite applications, criminal case and criminal appeal. Criminal appeal number 815 of 26.
Okay.
SRT criminal number 20248. Page 29 if you are also
Yes.
Initially, interim bail was granted, that was confirmed.
The learned counsel submits that the initially interim bail was granted by the Honorable Supreme Court arising out of the present FIR, and the said bail order has been confirmed by the Honorable Supreme Court. The order has been placed by the Annexure 1 to the rejoinder on behalf of the petitioner to the counter affidavit filed by the opposite party. The learned counsel further submits that a second supplementary counter affidavit has also been filed, wherein the present petitioner has been enlarged on bail in connection with
ACB FIR number 9 of 20.
ACB FIR number 9 of 2025. He has submitted that repeated FIRs have been instituted against the petitioner only to ensure that the petitioner remains in jail. That's all? Yes.
Lord, may I start my counter para 23, because his relationship with Vinay Singh and Snigdha Singh is admitted by him before us at para 23, just to show
23 of counter?
of my counter.
Yes.
That the petitioner was taken into 2 days of police remand for questioning, and during the course of interrogation he stated in relation to FIR accused Vinay Singh and Snigdha Singh that he had family relationship with them for about 25 years. However, on other points he did not provide clear answers during questioning and concealed facts. This fact is recorded in case diary 40 of para 361. A lady should have given it, it's at page 20. And I have marked.
Case ID para.
So whatever is in the index,
Yes.
it's
I'll
like-
calculate. Yes.
I am not reading.
That's not.
Yes. Then her ladyship may kindly come to the statement of Alka Kumari. That is important. Her ladyship is at page 6 of the paragraph is 17 of my petition.
This is para 17.
Yes. In fact, in the compilation, I have even given the paragraph numbers for her ladyship so that
Para 17.
para 17. That during course of investigation, statement of one witness under 183 has been recorded, and the said witness has clearly stated that the petitioner, by misusing his official position, forcefully got the land in question mutated in favor of Vinay Kumar Singh and Snigdha Singh, despite the fact that specific objection was raised by the said witness that the said land in question was Gair Vajulwa Khas Kisam Jungle land and the mutation of the said land cannot be done and or is illegal. However, due to undue influence exercised by Mr. Vinay Kumar Chaubey in pursuant to direction of petitioner, the mutation of the land in question was done in favor of Vinay Kumar Singh and Snigdha Singh. Her ladyship, her statement under 183 is at page 6 of the case of the record which I have given. Now, one more paragraph her ladyship would see is the statement which has been given by one another co-accused is para 24. He has not cooperated in investigation. His case is also when we issued him notices under 35(3). In fact, that matter is covered. He said that I am ready to become a government witness. I did everything because I was called in the chamber by. So he has not even appeared before us. But I'll just show that how he has given the reply to us. Para 24. That it is further stated that one of the FIR accused, namely Rajendra Prasad Singh, submitted a written reply to the notice issued by the IO, in which the said person stated that the mutation of the land in question was carried out improperly in favor of Vinay Kumar Singh and Snigdha Singh due to pressure exerted by the then Deputy Commissioner Hazaribagh, that is present petitioner. This fact has been recorded in para so and so and para so and so of CD. Copies of the reply sent by Rajendra Prasad Singh through post are also annexed herewith to evidence the aforesaid fact. I have annexed her reply, annexure D series. So, this person, in fact, today the anticipatory bail is listed. He had said, we will want to become a government witness. Your ladyship, the earlier honorable court permitted on that statement that we will not take any coercive action, come. He did not turn up, that is a different thing. But this reply is something which he has sent to us without even once appearing before us, and the reply which is completely tallying with the statement of.
What is his status?
But his status is absconding. He's not.
No, he's a government servant.
He's a government servant, now retired. But at the relevant point of time, for 5 years, he was the circle inspector at that point of time. Then her ladyship, there is one statement, para 21. Ashutosh. He has recorded his statement under 180. I'll just read. That during the course of investigation, the statement of the present circle officer Ashutosh was recorded under 180. In his statement, it was stated that no relationship could be established between the sellers of the land in question, namely Bhagwan Prasad Gupta and others, and the recorded Rayas in register to, namely Pradeep Kumar Jain and Rajesh Kumar Jain. Said fact is recorded in para 32, 299 and 300. I may just explain her ladyship. But the land is in the register 2 of sometimes in 68, 69 was recorded in the name of Pradeep Jain and Rajesh Kumar Jain. Sellers were a completely different person, Bhagwan Prasad Gupta and others.
That's right.
And there was no correlation between the register 2 entry and these persons. Despite the said fact, the mutation was done.
So this circle officer, Kumari, what's her name? She is not an accused in this
No, but
case.
we have still proposing whether we take her as an approver or we will take her as an.
Still proposing means what is going on and on.
Because some of the other charge sheet has been submitted as against the petitioner is concerned. But some of the accused are not cooperating, like Rajendra Singh is before her ladyship today. But another person is also there. Rajendra Singh is one important person, circle inspector, and Ram Prakash Chaudhary was the revenue Karamchari cum sub inspector, circle sub inspector. They both are not cooperating. They both say that we want to become witness. We offer them that you come to our.
Ram Prakash Chaudhary.
Yes, Ram Prakash Chaudhary. Today also his anticipatory is listed.
And his anticipatory is also there.
Yes, his anticipatory is also there.
There are two persons, circle inspector.
And he is the circle sub inspector come revenue Karamchari.
Circle sub inspector come revenue Karamchari. And this is circle inspector. Rajendra Prasad.
Regarding this particular case, because they are involved in other 22, 23 mutations also. But so far as the petitioner is concerned, we found in investigation only in one case where he has directly exercised influence. Now, kindly see her ladyship our statement with respect to linking the case with respect to the ill-gotten money.
Yes. So you want to say that if the petitioner is released on bail, these two persons can be influenced?
These two persons can be influenced, my lord, and my lord, the money trail and other things also could be influenced.
Where is the money trail?
Yes, money trail is para 31.
Yes.
That during course of investigation, it was found that another FIR has been registered against the petitioner and other, in which the petitioner, his wife, petitioner's acquaintance Binay Singh and his wife Signa Singh are named as accused. In this context, it is also stated that the said FIR was registered as ACB so and so under section so and so. Now, para 32 allegation that from perusal of the aforesaid FIR, it would be evident that during the period 2010-2015, a sum of rupees 3 crore 16 lakhs has been deposited in cash in the bank account of Brahmastra Education Private Limited, in which Swapna Sanchita, wife of Vinay Kumar Chaubey, and Shipish Trivedi, brother-in-law of Vinay Kumar Chaubey, are directors. And the layering of illicit money generated by Vinay Kumar Chaubey has been done through the said company. And then, well, this is one that she was running a company. In fact, we have got in investigation that the students shown to time, well, that the franchisee, say in a year was 100, and the money which is being shown to be deposited is of 5,000 students or 2,000 students, and all those are deposited in cash as the tuition fee. So time is getting a franchisee of say 100 students for the fees, and actual deposit of money in the account
is much more,
and those students are shown. Of course, we have got names like Shah Rukh Khan, Amir Khan, and other students are also being admitted like that in the institution. Then, my lord, kindly see para.
Is there any legal bar that anyone
No, I can't.
have a name of Shah Rukh Khan?
No, I am not saying at all. I am only amazed that my name does not appear there or my senior colleague's name does not appear there. So, this is what prima facie we have found. Then, para 33 is a ladyship. This is, my lord, Swapna Sanchita was directly, my lord, shown to be working as a consultant with Binay Singh in our company. And it is said that she was paid 1,50,000 per month as salary. Now, we have got no appointment letter. If she is a consultant, there has to be a bill raised if TDS is deducted at the rate of 10% towards professional services. No bill has been found. So, all these are linking the petitioner with the Binay Kumar Singh and the transactions which have taken. So, I have spelled out everything in detail in my counter affidavit. And, my lord, everything, my lord, I have just given for her ladyship convenience in the case diary part.
The learned counsel for the ACB has referred to paragraph 23 of the counter affidavit to submit that when the petitioner was questioned, he admitted that Vinay Kumar Singh and Snigdha Singh were having family relationship with the petitioner for last 25 years. He then referred to paragraph 17 to submit that one of the witnesses, namely circle officer, has given her statement under section 183 of BNS that the petitioner by misusing his official position forcefully got the land in question mutated in favor of Vinay Kumar Singh and Snigdha Singh. Despite specific objection being raised by her that the land was Gair Majurwa Khas Kism Jungle land and the mutation of the said land cannot be done. And consequently, the mutation was done in favor of Vinay Kumar Singh and Snigdha Singh. He has then referred to paragraph 24 of the counter affidavit to submit that the co-accused, namely Rajendra Prasad Singh, who was the circle inspector, had suo motu submitted a reply to the investigating officer of the case that that there was a pressure from the petitioner to carry out the mutation in favor of Vinay Kumar Singh and Snigdha Singh. The learned counsel submits that the anticipatory bail of Rajendra Prasad Singh is pending before this court. He has then referred to another co-accused, namely Ram Prakash Chaudhary, whose details have been mentioned in paragraph number. Ram Prakash Chaudhary लिखे हैं यहाँ.
हम उनके बारे में लिखे नहीं हैं, बता रहे कि उनका भी एंटीसिपेटरी पेंडिंग है.
Okay, the learned counsel has submitted that another co-accused, who is the circle sub-inspector, namely Ram Prakash Chaudhary, his anticipatory bail is also pending before this court. The counsel has submitted that Ram Prakash Chaudhary, that if the petitioner is released on bail, there is a likelihood that he would influence the aforesaid two persons whose anticipatory bail is pending. The learned counsel then referred to paragraph 21 of the counter affidavit. To submit that the vendor of the land in question was never Bhagwan Prasad Gupta and others. Rather, it was recorded in registered to in the name of Pradeep Kumar Jain and Rajesh Kumar Jain. He submits that as the vendor of Snigdha Singh and Vinay Kumar Singh was never Bhagwan Prasad Gupta, there was no occasion to carry out mutation in the name of Snigdha Singh and Vinay Kumar Singh, who were the vendors from Bhagwan Prasad Gupta. And everything has been orchestrated at the instructions of the president.
Vendors were Bhagwan Prasad Gupta, but they had no title.
They had no title. I mean that only. He said that Bhagwan Prasad Gupta did not have title with respect to the property, and therefore they could not have been a vendor. In the mutation proceedings, the title of the vendor is required to be seen. That's all.
And my lord, about that cases I just mentioned.
Yes.
Para 31 and 32. 31, 32, 33.
That's right. The learned counsel has then referred to paragraph 30, 31 and 32. 30, 31 and 33. Para 30 to 33. To submit that the entire money trail and the manner in which the money has transferred and deposited in the account of one Brahmastra Education Private Limited, in which the wife of the petitioner and brother-in-law of the petitioner are the directors. There is a cash transaction, there is a cash deposit of rupees 3,16,81,597 during the period from 2010 to 2015, and he submits that the said company, namely Brahmas Education Private Limited, is only a cloak to give legitimacy to the money transaction. Rather, the company was used for layering of illicit money generated by the petitioner. उनकी वाइफ भी accused हैं. Snigdha is an accused.
इसमें accused है 20 of 2025 में accused है. हाँ भाई 20 नहीं.
The learned counsel has submitted that another case in that connection has been registered, which is ACB Ranchi PS case number 20 of 25 dated 24/11/2025, in which the petitioner as well as his wife and also Vinay Kumar Singh and his wife Snigdha Singh are named accused. That's all. He has also submitted a list of relevant paragraphs of the case diary and statement of the witnesses recorded under section 180/183 of BNSS during the whole proceedings. इसमें charge sheet has been submitted. The counsel for the petitioner has submitted that charge sheet has already been submitted against the petitioner on
5/2/2026.
On 5/2/2026. That's all. Yes, sir. वो जो दोनों रिजर्व किए थे वो कल आएगा ऑब्वियसली टुमारो.
Item 20 DA 1134/2026.
Lord, the present case arising of the same fire, Lord, the petitioners before Rossi, Lord, are the power of attorney holder. And Lord, they said, Lord, they have got the power of attorney from Lord the landowner. Therefore, Lord, they have been implicated in jail, Lord, and been implicated in this case, and they are using in jail, Lord, 6/12/2025. The charges, Lord, have been submitted. They have got no clemency.
Custody since?
Pardon?
Custody since?
Custody, 6/12/2024. Except Lord,
Charge sheet submitted.
charge sheet submitted.
On?
Charge sheet has been submitted. Was
26 to 26. Under which section?
under section Lord 420, 467, 468, 471, 120B, and under section 32, there is section 31D of the PCA. Lord, so far the petitioners are concerned, there is no application of Lord the section 32 and 31D of the PCA. They are private property. They are the co-villagers. They have got Lord the power of attorney from Lord the landowner, that is apparent. When
120B is there, then under such circumstances,
so far
13(1) and 13(2) is not applicable.
120
Yes, when 120B is there
with the IPC.
with the IPC,
Yes.
then these PC Act will not be applicable.
No, the PCA, because they are not in the public servant, and they have not, there is nothing that they have not the conspired together with the public servant. No, they are in two parts.
They are the vendors. They are the vendors representing the vendors. These are the power of attorney holders and therefore representing the vendor of the property.
Yes. On behalf of Lord the real owner of the land, Lord, my Lord will find from Lord the power of attorney, I have annexed Lord, page 61.
We will see that, and let us see the allegation against.
Yes, Lord, the allegation, Lord.
Where is the FIR? Where do I find the allegation against him?
My Lord, this second part of Lord the FIR. Lord, the page 24.
Yes, I am there.
This Lord the regarding खाता संख्या 95 प्लॉट संख्या 848 गैर वजीफा खाते की भूमि है जिसका किस्म जंगल है इस भूखंड के लागत खरीद पर आपूर्ति है क्योंकि अगर वजीफा खास किस्म जंगल भूमि है इसका गैर वाणिज्यिक कार्य हेतु उपयोग माननीय सर्वोच्च न्यायालय द्वारा रीट संख्या डी गोदावरमन 600 से प्रावधान है इसी खाता 95 एवं प्लॉट 848 से 28 डिसमिल जमीन विनय कुमार सिंह पिता साधु चरण सिंह और श्रीमती स्निग्धा सिंह पति विनय कुमार सिंह द्वारा क्रय किया गया है तथा दाखिल खारिज भी किया गया है जबकि इसी तरह के जमाबंदी का वो गलत माना गया है तथा जमाबंदी रद्द तक की गई तथा स्पष्ट है कि क्रेता विनय कुमार सिंह पिता साधु चरण सिंह एवं श्रीमती स्निग्धा सिंह पति विनय कुमार सिंह का खाता संख्या 95 प्लॉट संख्या 848 अथवा 28 डिसमिल भूमि का गलत तरीके से जमाबंदी किया गया। इस अवैध जमाबंदी को तत्कालीन राजस्व कर्मचारी संतोष कुमार वर्मा तत्कालीन तत्कालीन अंचल निरीक्षक राजेंद्र प्रसाद सिंह एवं तत्कालीन अंचल अधिकारी श्रीमती अलका कुमारी द्वारा 18/8/2010 को किया गया है। प्रारंभिक जांच से क्रम में स्थापित हुआ कि उक्त प्राधिकारी कर्मी द्वारा पद का दुरुपयोग करते हुए क्रेता एवं विक्रेता से आपस में षड्यंत्र कर सदोष लाभ प्राप्त करने के उद्देश्य तथा सरकार को हानि पहुंचाने के नियत से उक्त अपराध कारित किया गया। The petitioner have not sold the land to either to Vinay Kumar Singh or in favor of Sridhar Singh.
But the deed was executed through you because you had the power of attorney.
No, the landowner has given the power of attorney.
That's right.
We have not sold these persons.
No,
We have not sold these persons.
you are the power of attorney holder.
Holder of what has happened is here.
No, just let my question be over. Like, you are the power of attorney holder. Did you execute the deed?
Yes.
And in the capacity of power of attorney.
Very good.
Very
I was not the deed also, my lord.
That's right.
Yes, but I was present for also, my lord, that so far, Lord, is the whole case, Lord, the revolving, Lord, the round Vinay Kumar Singh and Sridhar Singh, Lord, we have not sold them. We have not sold the land, Lord, to them. Thereafter, my lord, my name, Lord, it comes later on in this Lord deed.
So how do you see that you have not sold the land to Vinay Kumar Singh and Sridhar Singh? You have executed the sale deed on behalf of the owner of the land.
Yes, Lord.
You are not the seller technically,
Yes.
but you have executed the sale.
Executed, Lord, the deed.
I will not interfere, but the time miss हो रहा है। ये उस portion का FIR नहीं लिखा, आपका allegation लिखा, आपका 23 में।
हाँ, वही बोले ना।
कहाँ 23 का एक बार दिखाइए कहाँ?
But in यही FIR है, but with respect to 23 cases, not this 28 decimal of Vinay Singh and
हाँ, हम वही उसके बाद ही पढ़ रहे हैं।
तो कौन सा है इनका?
इसमें जो है मेरा नाम देखा जाएगा में कि यही पढ़ने का तो क्लियर इसी के बाद
पढ़िए।
अतः उपरोक्त परिप्रेक्ष्य में पाए गए साक्ष्य के आधार पर सदर अंचल हजारीबाग के तत्कालीन अंचल अधिकारी अंचल निरीक्षक अधिकारी अलका कुमारी अंचल निरीक्षक राजेंद्र प्रसाद सिंह तत्कालीन राजस्व कर्मचारी रामप्रकाश चौधरी तत्कालीन राजस्व कर्मचारी संतोष कुमार वर्मा श्री भगवान प्रसाद गुप्ता ईश्वर दयाल गुप्ता इंद्र प्रसाद गुप्ता रामवृक्ष गुप्ता रामकिशोर गुप्ता रामज्योति गुप्ता बलवंत गुप्ता सो अटॉर्नी होल्डर धनेन्द्र कुमार श्री बाल गोविंद साव श्री अमृत कुमार श्री नंद किशोर प्रसाद श्री निरंजन कुमार विनय कुमार सिंह श्रीमती स्निग्धा सिंह शशि शेखर प्रसाद रामधनी राम देन राजेंद्र प्रसाद संजय शेखर देवेंद्र प्रसाद प्रेम प्रसाद गुप्ता इंद्रदेव प्रसाद श्री लाटो प्रजापति देवी प्रजापति मानके प्रजापति देवी प्रजापति कुलू प्रजापति निमिषन प्रजापति तिलक प्रजापति योगेश्वर प्रजापति कुलेश्वर प्रजापति शंकर प्रजापति विशेश्वर प्रजापति लखेंद्र प्रजापति छत्रु प्रजापति रामदयाल प्रजापति राजकुमार प्रजापति बसंती देवी पारो देवी सुनील कुमार प्रसाद जयप्रकाश कुमार बबलू कुमार प्रशांत कुमार प्रधान प्रदीप प्रसाद राम प्रकाश माली रश्मि प्रसाद प्रकाश कुमार सिन्हा सौरभ कुमार श्रीमती सीमा सिन्हा अर्चना देवी डॉक्टर राजीव कुमार अनिल कुमार सिंह रेणु देवी श्रीमती मुनिया देवी निर्मली जयप्रकाश यादव पिटिशनर नंबर 2 हाँ and 61 मोहम्मद कदम these are two petitions
60 and 61 just a moment 61 is Jayaprakash and 60
ये उसमें क्या लिखे आगे में 72 है 71 अनिता कुमार सिंह 72 किरण सिन्हा संजीव कुमार सिंह क्रम 1 से 5 तक के द्वारा सरकारी पद पर रहते हुए अपने पद का दुरुपयोग करते हुए तथा अन्य के साथ आपराधिक षड्यंत्र से कूट रचना करते हुए सामूहिक तौर पर अनैतिक लाभ का प्राप्त करते संज्ञेय अपराध करने का Lord, you want to file or Lord the publisher?
So you are the power of attorney holder with respect to which property?
Lord the plot number 848 1062 and 1063.
Which has been sold to whom?
Lord, that is sold to Lord, that is deed is there in favor of Samir Kumar Sahai.
Okay, somebody else.
Somebody. And then Lord land was located.
That was also, but allegation is that it was forest land.
But it is for attorney holder, and that would have been done in the year 2011. In the counter letter has stated that the list which has been that has come published in the year 2012. Prior to that, the power attorney holder they had sold the property of the power.
What is the list?
List that is regarding paragraph 14 NDC. During the course of investigation, one letter issued by the Office of Divisional Forest Officer Hazaribagh, is Forest Division, 5 letter number, date 2612 dated 5/12/2012 was considered, where it has been clearly stated that non-forest use or encroachment over notified land is a matter of violation of Indian Forest Act. This paragraph 14 of the counter.
And you're saying it was executed in the year 2011.
On 19, Sally was executed on 30th May 2011 on the basis of the power of attorney dated 19/4/11. For that, they are in jail since 6/12/2025. The landowner has stated that what will be, whatever loading will be committed by the power of attorney, that will be binding upon him. That is evident from page 64.
The learned counsel for the petitioner submits that the petitioners are the power of attorney holder with respect to some of the properties which were sold and they were alleged to be forest land. He has further submitted that though it is alleged that the accused persons connived with the government officials for the purposes of transfer and mutation of property, but the petitioner, being the power of attorney holder, has no role. He has further submitted that the sale deed was executed by virtue of General Power of Attorney number 429 of 2011 to one Samir Kumar Sahai through registered sale deed number 6085 of 2011. But the government had taken out a letter number 2612 dated 5/12/2012 cautioning the persons, public at large, not to deal with forest land. He submits that the petitioner, being the power of attorney holder, is not a beneficiary of the same transaction, but he had only executed the sale deed on behalf of the owner of the property. And there is allegation that the purchasers of the property connived with the government officials to get the property mutated in their name. The petitioner is in custody since 6/12/2025 and charge sheet has been submitted on 26/2/2026 for offence under section 420, 467, 468, 471, 120B, read with section 13 within bracket 1 and 13 within bracket 2 of the Prevention of Corruption Act. He submits that the provisions of Prevention of Corruption Act does not apply upon the petitioners. Yeah. Yes, take. What is their role in approaching the government officials in getting the mutation done? Sale deed is there, right? Sale deed is there, but the entire allegation is the mutation. What is their role in getting the mutation done?
To be investigation to that extent, their specific role on mutation done is not there.
So they are entitled to go.
Because we have said that thereby power of attorney holders mutations have been illegally done.
That's
but to identify these two power of attorney holders that they got the mutation done, but I may not be able to say.
The learned counsel for the respondent, though has opposed the prayer and has referred to the counter affidavit, but the submissions which has been made by the learned counsel for the petitioners that they are the power of attorney holders, and as per the allegation, the purchasers of the property connived with the government officials to get the mutation done is not in dispute. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances and the custody of the petitioner since 6/12/2025 and charge sheet having already been submitted, the petitioners are directed to be enlarged.
We say that nothing stated in our counter.
Okay. Nothing in the counter affidavit also. No particular role of the petitioner has been mentioned
Regarding mutation.
regarding his role in getting the mutation done in favor of the purchasers of the property.
Item 21 BA1410/2026.
Counsel for the petitioner seeks permission to withdraw this petition. This petition is dismissed.
Signed for the Item 22 BA1602/2026.
Counsel.
Item 23 BA1681/2026.
Yes, not filed counter because it was earlier wrongly listed before Honorable Court number 9, and then it was directed to be listed before the appropriate bench. If a ladyship permits, I just filed counter in this case.
He is in custody for more than 3 months now.
But in this case, I don't have facts. Maybe give us 1 week in this time.
More than 3 months. Is the seller mutations of minor pyramid?
He is a seller.
One of the sellers.
Arising out of the
His
same.
counter has been filed. Therefore, I am the seller, he is the purchaser. Who accused has been granted bail by the Supreme Court, the charge sheet has been filed.
But
In
he
my-
wants to file a counter affidavit. Let him
No, in my case, it has been filed.
We are not on your case.
I was saying my case can govern his case also.
I don't know.
Just give me 1 week time or we'll do it next week.
Learned counsel for the parties are present. The learned counsel for this ACP Lanchi prays for and is granted 1 week time to file a counter affidavit in this case.
Let come next Thursday. You can verify Wednesday.
The counter affidavit will be filed by next Wednesday, post on Thursday. यहाँ से फाइल कर देंगे यहाँ पर कोर्ट में मत फाइल करेंगे अब वो कंपैरिजन भी जो आप फाइल करते हो
Item 24 BA1701/2026.
Is 24. Who are you?
I am the giver, power giver.
Sorry?
Power giver. I have given the power attorney.
So you are the owner of the property.
Yes.
Serial number 22, Mohammed Kallan, that your lordship has just granted, ladyship has just granted bail.
Yes.
They are the owners of those. So they have sold the property through Mohammed Kallan to the purchaser.
इनका कोई रोल
मतलब रोल यही है कि मतलब जो प्रॉपर्टी फॉरेस्ट लैंड था ये लोग इसको बेच रहे थे. This is what we have alleged. That they could not have sold the land in question at all. And an entire transaction of sale also and subsequent mutation in favor of the purchaser was with the connivance of the government office.
सेल में तो किसी गवर्नमेंट ऑफिशियल का कोई कन्वेंस
हाँ नहीं वो तो रजिस्ट्री ऑफिस से होता है.
वो तो रजिस्ट्री ऑफिस सारा कहानी म्यूटेशन का है एलिगेशन आपका पूरा का पूरा म्यूटेशन
म्यूटेशन है.
सेल तो यू सी यू कैन गो एंड सेल रांची रेलवे स्टेशन रजिस्ट्री ऑफिस क्या ही करेगा वो उसका काम है स्क्रूटिनी करना दे हैव देयर ओन
I go down to that extent.
So, buyer and officials का bail मिलना मुश्किल है, लेकिन so far as the sellers are concerned,
Actually, what is happening is कि ये सब of course, general what is happening is the sellers also the sellers are getting lands identified, those which are vacant, otherwise not sellable, and they are selling it to the buyers, showing that all documents are there. And of course, at the stage of registry, that cannot be looked into to a great
उनको
extent.
mutation में ही पता चलता
हाँ, म्यूटेशन में ही पता चलता है. म्यूटेशन के समय में
है। वो खाली लाइन दिखाया प्लॉट नंबर सो एंड सो,
हाँ,
उसके बाद प्लॉट नंबर सो एंड सो करके बन गया, देन दे डिस्कवर दैट इट्स अ डोमेन लैंड। आपका डीड कब हुआ है इसमें? बाकी सब कोई चूज तो बिल रिजेक्ट हुआ है, लेकिन सेलर्स का तो नहीं रिजेक्ट हुआ किसी का। यस,
हाँ नहीं अभी तक सेलर का
Seller
और
का
पावर
तो-
ऑफ अटॉर्नी होल्डर का नहीं हुआ, अभी पहले ही
पावर
चालू
ऑफ
हुआ है.
अटॉर्नी होल्डर का भी मैंने दे दिया बिल।
हाँ,
नाउ इट्स अ टर्न फॉर दिस।
सेल.
थोड़ा बताएंगे।
Whether the land belongs to the petitioner also. Kindly see page 76. 76. The forest department has given the permission for cutting the tree also. Page 76. हल्का कर्मचारी श्री लाल चंद्र राम.
What is the date? Date of this document? 5/11/2002.
Yes. 5/11/2002.
This was given by the circle officer.
Yes. Thereafter, Lordship, the Department of Forest, 77, page 77.
How do you say that you are the owner of the property?
According to the Hukumnama, Lordship.
On the basis of
On the basis of Hukumnama given on 11/10/1929.
and you were in possession.
Yes, sir. Thereafter, the Jamabandi record has been opened, Lordship, page 83.
When was Jamabandi open?
Yes, sir. Jamabandi. The certified copy of I opened was 29/5/1984.
1980. Oh, you obtained this anyways.
And thereafter the rent receipt was in page 80-81 also. And the last rent receipt, page 69.
When did you sell this property? What is the
Yes,
date of
yeah,
sale? Is 2011.
Even the power of attorney Lordship on 5/9, no,
Power of attorney.
page 55 Lordship,
Yes, what is
19/4/2011.
19/4/2011, and it was sold in the year 2011.
Yes, page 55, the power of attorney.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner is the owner. The petitioner claims to be the owner of the property which has been sold in the present case by alleging that it was forest land. He submits that the petitioner claims title over the property by virtue of Hukumnama dated 11/10/1929, which was, and Jamabandi was opened in the name of the petitioner, and rent was also paid to the state. He has further submitted that he had executed power of attorney in favor of the co-accused on 19/4/2011, and ultimately the property was sold through the power of attorney in the year 2000. The learned counsel submits that the entire allegation in the FIR is in relation to connivance of the purchaser of the property with the government officials in the matter of opening of in the matter of mutation with respect to the property involved in this case and other properties also. He submits that No specific role has been assigned so far as the petitioner is concerned, except that the petitioner had sold the property. The learned counsel for the learned counsel has also submitted that the power of attorney holder has been enlarged on bail by this court today itself in BA number
1134 of 2026.
1134 of 2026. The petitioner is in custody since 6/12/2025. Charge sheet has been submitted?
Yes.
Charge sheet has already been submitted. The learned counsel for this opposite party, ACP, has opposed the prayer. However, no specific role has been mentioned so far as the petitioner is concerned in the complaint. Regarding the mutation, which is the basis for institution of the case. After
one line can be recorded. That these lands were forest lands, so petitioner could not have sold the land. That is.
He has also submitted that the petitioner could not have sold the land as the land was forest. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, and as per the FIR, the allegation centers around mutation pursuant to the after hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, and no specific role has been mentioned in the counter affidavit with respect to the petitioner, except that he has sold the forest land through registered deed executed by power of attorney, and power of attorney has already been enlarged on bail by this court. And considering the custody of the petitioner since 6/12/2025, the petitioner is eligible to be enlarged. और सेलर लोग का है यहाँ पे बताइए।
Item 25 BA 1829/2026.
96 and of the BNS and 8 and 12 of the Constitution. 366 there. Let's see what else they have tried for a while. That's page 15. मेरी मेरे को कहना है कि मैं अगर महिला उम्र करीब 35 वर्ष जसु महारा राम गुरुजी टोला राणावत थाना नारायणपुर जिला जामताड़ा का रहने वाला दिनांक 7/10/2025 को हम सब परिवार खाना खाकर सोए हुए थे। दिनांक 8/10/2025 को करीब 3 बजे सुबह उठे तो देखे कि मेरी भतीजी हीना कुमारी
Don't take the name.
सॉरी मेरी भतीजी 15 वर्ष समर्थ मेहरा के घर पर नहीं है। इसके बाद तुरंत हम लोग घर वाले खोजबीन करने लगे। काफी खोजबीन करने के बाद पता चला कि मेरे ही गांव के दुर्गा दास पिता वरुण दास पिटिशनर लेडीशन मेरी भतीजी रीना कुमारी को शादी करने का नियत से बहला फुसलाकर चला गया। 8/10/2025 को शाम में जब मेरी भतीजी रीना कुमारी घर वापस आई तो मेरे पत्नी माँ एवं घर में अन्य महिलाओं के द्वारा रीना कुमारी से पूछने से बताई कि गाँव के दुर्गा दास पिता वरुण दास नियत से बहला फुसलाकर गाँव के पीछे लेके चला गया और दुर्गा दास
Let notice be served upon the informant of the case.
Notices were issued the last occasion. Notices were issued. And I filed a notice on 17/3/2026.
No counter affidavit has been filed.
Yes, ma'am. No counter affidavit has been filed. And
Where is Mr. V.S. Sahan? Service of notice is not there on that.
That will be issued. The awaiting service notice after 1 week. Or in the meantime, the diary or the counter is to see the statement
A
of
number 1829 of 2026. In spite of order dated 13/3/26, no counter affidavit as such has been filed. Let the case diary along with the statement of the victim and her medical examination report be called for from the concerned court. The learned counsel for the state is directed to file the counter affidavit by 11th of May. Pose this case on 13th.
183 statement and 164 statement.
Yes.
That there is
183 I have already asked. Along with 183 statement and medical examination report.
always.
Since the counsel for the state is not appearing, let a copy of this order be forwarded to Mr. V.S. Sahai. V.S. Sahai BAPP है ना?
I will inform
To ensure compliance. Soft copy forward कर दीजिए.
Item 26 BA 2095 of 2026.
Yes, petitioner.
Application. Pre-trap owner demanded 25,000. Post-trap owner, he was not returned with 25,000.
What is the status of the petitioner? He is
Yes.
designation.
Block coordinator.
Block coordinator.
Yes, sir.
For what purpose the demand was made?
For releasing the payment method. Relating to the construction of suit.
Payment. Custody.
3/2/2026. Charge sheet on 1/4/2026.
Or the learned counsel appearing on behalf of the petition, on behalf of the parties. The petitioner is alleged to have been caught red-handed with bribe money of ₹25,000. And he was working in the capacity of block coordinator. And it is alleged that he demanded bribe of ₹25,000 for releasing payment relating to construction of circuit. The learned counsel for the petition submits that the petitioner is in custody since 3/2/2026 and charge sheet has already been submitted on 1/4/2026. The learned counsel for the state has opposed the prayer and has submitted that there is the petitioner having got with bribe money red-handed, he may not be released on bail. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, this court is not inclined to enlarge the petitioner on bail. At this stage, however, the petitioner may review his prayer for bail after 6 months.
One difficulty in one case also. Sanction has not been, public has not been taken for what of
The learned counsel for the petitioner has also submitted that the cognizance is not being taken on account of want of prosecution sanction and FSL report. To this, the learned counsel for the opposite party has submitted that the state shall make all endeavour that the formality, that the required sanction and the FSL report, the required sanction, the matter regarding sanction is taken to a logical end, and FSL report is also submitted before the concerned committee. Renew after 6 months.
3 months.
6 months.
लास्ट केस में आप 4 दिए
कोई बात नहीं. Nature of allegation बहुत मैटर करता है.
नेचर
कंस्ट्रक्शन का काम करके पेमेंट नहीं करना.
कंस्ट्रक्शन तो कुछ नहीं है, कंस्ट्रक्शन तो होएगी. दैट केस में
कोई प्रेसिडेंट की तरह नहीं है सर. 6 months.
The sanction part was there, then your lordship said maybe.
That's right. 6 months.
Item 27 VA 2685 of 2026.
Case under POCSO Act, petitioner is not named in the FIR. The FIR is in case number 15 is the parcel for the rest of the FIR stating that she was celebrating marriage in the night along with the other person.
What is the age of the victim?
Victim age about is last year student about 14 years.
14 years.
Yes, she is saying 14, but it is more than 15 years old. And petitioner is not named in there. She was celebrating marriage along with her. In the meantime, the Prithamna has taken her towards the.
It's a case of gang rape.
Yes, 2 persons.
Heard the learned counsel stating on behalf
Petitioner
of.
is neither named in the FIR, nor anything ingredient required from his person. His name has come only on the basis of the confessional statement of co-accused.
And also the statement of the victim.
No. Never. Even her statement under 164, she has not taken name of the prisoner. He has not been put on TI parade, nor he has produced neither she was updated.
Just a moment. The learned counsel for the state is directed to procure the FSL report. FSL report. सारा कहानी उसी में. From the concerned laboratory.
No problem. But it is the way who is named in the FIR.
FSL report आने दीजिए. फिर आपको बेल देंगे. आपका कोई भी लिंक नहीं मिलेगा तो आपको बेल देंगे.
वो एक जो है प्रीतम डॉग
We'll see that. आप FSL report लेके आइए. ये FSL report के चक्कर में ये सारा पॉक्सो केस पेंडिंग रहता है. ठीक है? मेडिकल रिपोर्ट तो इंसिडेंट तो हुआ है. पिटिशनर किया है कि नहीं ये कहानी. इंसिडेंट हैज हैपेंड. देयर इज नो डाउट ऑन दैट. व्हाट इज देयर? यू हैव फाइल्ड योर काउंटर एफिडेविट. व्हाट इज देयर टू लीक द पिटिशनर? FSL रिपोर्ट लेके आइए. पोस्ट ऑन 13th में इन सीट कवर में लेके आएंगे.
Passover case item 12 ABA 7079 of 2025.
इसमें एक चीज और लिखी है. इसमें शायद लोग केस डायरी नहीं आया.
केस डायरी है.
आया है इसमें. Yes, Passover.
The petitioner is a retired circle inspector now, retired as assistant settlement officer, and the allegation against him.
Retired circle inspector at that point of time.
Circle inspector at the point of time where 15 years back, Lord, after 15 years this FIR is being logged. Lord, on the allegation no facts are stated, only on opinion that the mutation that were recommended by the circle officer for mutation. Now that recommendation was collusive in with the purchaser and seller, because the khata number 95 not of the Mauja in question, some plots are recorded as jhari jungle jhar. Now this is the allegation in nutshell in the FIR. My humble submission for your lordship's consideration. We always learn from the judgments of the Honorable High Court as well as the Supreme Court. Your lordship's judgment is also on this, that where there is a long-standing jamabandi. Now and continuous possession, so many mutations rolled by. It is not the first mutation which is being alleged as against us in the FIR. It is not the first mutation. In the whole of the FIR, this fact has been suppressed, which has come in the counter. Counter ka inka ek
how many jamabandis have been there one after another?
हाँ जी हाँ, और 1919 से इन खाता नंबर 95 वो भीम सेन महतो उनके नाम से इनके मैंने जो प्रेजेंट सेलर हैं जिन्होंने सेल डीड किया और जिसके एवज में जो म्यूटेशन की बात आ रही है कि हम लोगों ने म्यूटेशन के लिए रिकमेंड कर दिया, तो लॉन्ग स्टैंडिंग इन जमाबंदी मिलॉट एंड बाय रजिस्टर्ड ये हुजूर के जजमेंट में किया है। हुजूर के जजमेंट भी हम लोग और भी ऑनरेबल हाई कोर्ट के जो जजमेंट्स हैं वो सब उसमें हम लोग लगाए हैं। नॉट इन सप्लीमेंट नॉट इट्स नाउ सेटल्ड बाय योर लॉर्डशिप्स that where there is a long standing jamabandi, even if gair majurwa khas lands or whatever recorded of the government, question is long standing and your lordships have emphatically said that no can't be cancelled summarily. हुजूर का एक सच्चिदानंद करके भी एक केस है जो हम लगाए हैं, that summarily you can't cancel. And then what wrong I have committed, Lord? This is for your lordship's consideration. I am harping on this because there is one judgment which we have annexed also, Lord, of this honorable court, in which, my lord, the purchasers and circle officer, they were all accused, Lord, in this case. Now, old standing jamabandi, referring to those facts, my lord, this honorable court, in the case of Lord Naresh, in the case of Lord Dinesh Kumar Sinha,
you see, we are not on any.
No criminal offence is made out. This is what I am harping on.
Circle inspector is required to go on the spot, isn't it, and find out.
And the possession is admitted. They don't say कि possession में नहीं था. लॉन्ग स्टैंडिंग ये जमाबंदी नहीं था और आज भी पोजीशन है और आज तक उसके बाद ये 15 साल की पुरानी बात है और आज तक कैंसिलेशन के लिए कोई 4H नहीं हुआ।
जो वेंडर है इसमें, जो वेंडर है, कौन है वेंडर? हु इज द वेंडर?
वेंडर तो कई हैं इसमें 23 केसेस आ गए।
एक का नाम बताइए ना, एक का नाम बताइए। हु इज द वेंडर? Who is the vendor?
वेंडर का तो नाम हम अभी एग्जैक्ट नहीं बता पा रहे हैं, लेकिन वेंडर की जो दादी है कपूरी देवी, उनके नाम से बहुत पहले रिकॉर्डेड है 61 वगैरह और 1990 इनका काउंटर का हुजूर
कहाँ से बोल रहे हैं सर? आप हमको रिकॉर्ड से दिखाइए। आप
इनके काउंटर को देखा जाएगा,
आपके पिटीशन को ना देखें,
इनके काउंटर को जरा
ये जरा FIR देखिए।
FIR पेज 24। Should I read it? For the relevant
ये है ना खाता नंबर 95 की कहानी है कि इसके अलावा भी कहानी?
95 खाता को लेकर ही कुछ प्लॉट्स लग रहे हैं जो 23 केसेस आर देयर ऑफ
But all relating to खाता number 95.
95
Plot number 848.
एनेक्शर
28 district. Correct?
एनेक्शर ए ही लगाए हैं पूरा लिस्ट केसेस 23 केसेस का जिसमें खाता नंबर प्लॉट नंबर सब है वो जैसा देख लिया
Annexure A.
पेज 53 पर भी है मेन पिटीशन क्योंकि इट इज पार्ट ऑफ द एफआईआर
Page 53.
Page 53. Your Lordship sees, Lord.
ये जितना दाखिल खारिज ये सब सेम डे में हुआ है. All the mutation has been done on the same day.
No.
Almost.
October 2011 से शुरू हुआ. There are several orders.
You see, there are at least initial 7 orders are of 2010-2011.
Lord. 20 अक्टूबर 11. उसके बाद जो है 9/11/11 28/11/11 28/11 then 6/2 your lordship seeing now
Yeah, yes sir.
29/2
What do you want to
11/3 और 16/3 16/3 16/3 16/3 16/3 21/3 not
आप हमको सिर्फ इतना बता दीजिए वेंडर के नाम पे प्रॉपर्टी रिकॉर्डेड था क्या? कहाँ से बोल कहाँ से बोल क्योंकि इनके काउंटर एफिडेविट में तो आया है कि एक के नाम से तो प्रॉपर्टी रिकॉर्डेड भी नहीं था सब जैन या कुछ ऐसा
इनका काउंटर का पेज 21 देखा काउंटर
पेज 21
मिलो
क्या है पेज 21
पेज 21 का फर्स्ट पेज जो देख रही हैं ये कर्मचारी का रिपोर्ट है और नेक्स्ट पेज में द पिटिशनर का रिकमेंडेशन तो ये फर्स्ट पेज जो 21 है उसको जरा सा ऊपर हम पढ़ते हैं मतलब इसमें लॉक्स नहीं मिला
You are the circle inspector.
Circle inspector. I am not the final authority. However, recommendation. Recommended. आवेदित खाता नंबर 95 सर्वे गैर मजुरवा खास भूमि है विक्रेता के परदादा भीमनाथ महतो के नाम से बजरिए खरीदगी केवाला नंबर 129 1919 माइल से हासिल है केवाला नंबर 129 1919 उसके बाद पंजी के 2 के पेज नंबर 117 बी में विक्रेता की दादी कपूरी देवी के नाम से जमाबंदी का नाम है एवं रसीद निर्गत हो रहा है माय लॉर्ड कपूरी देवी के दादी माने सेलर की दादी एवं रसीद निर्गत हो रहा है कपूरी देवी के नाम से रिटर्न भी दाखिल है माय लॉर्ड रिटर्न भी दाखिल है विक्रेता अपने घरेलू बंटवारा के आधार पर यह अपने हिस्से की भूमि को बिक्री किया है गैर मजुरवा आम गोदान भू हदबंदी शराब केसर हिंद वन सीमा के बाहर क्रेता को भूमि पर दखल है दखल एंड देन नॉट नीचे नामांतरण हेतु आवेदित भूमि गैर मजुरवा खास खाते की है नाउ देन इसके बाद जो देखा जाएगा नाउ दिस इज
not the petitioner who is जमीन विक्रेता के दादी कपूरी देवी के नाम से जमाबंदी कायम है.
The learned counsel for the petitioner submits that the petitioner is the circle inspector on whose recommendation the mutation has been done. He has referred to the report annexed along with the counter affidavit and has submitted that the entire history of the property bearing khata number 95 has been mentioned therein, indicating that the property was purchased in
by
the name of
Bhimnath
by Bhimnath Mehto, by registered grandfather of the vendor by Sally number 129 of 1919, and then the property was Jamabandi was subsequently created in the name of the vendor, the grandmother of the vendor, namely Kapuri Devi, and the rent receipts were also being issued in her name, and she was in possession of the property. He has also submitted that while making recommendation, a reference to the return filed by the Zamindar was also mentioned. The learned counsel submits that the petitioner has no role in the alleged offence, and the recommendation was made on the basis of materials discussed in the recommendation. Custody कब से? अच्छा anticipatory. बताइए, आप स्टेट्स हो गया, काफी है इतना काफी है, और कुछ बोलना है?
उनका जजमेंट ये है, हम क्या बोले? No offence lot is made out.
The learned counsel submits that no offence is made out. The matter relates to the title of the property, that there is long-standing Jamabandi in connection with the property.
And so long, until today, no cancellation proceeding is started lot against these. आज भी possession में लोग ये लिखवा दिया जाए.
चलिए क्या बोलना है? State.
But he was one of the key persons. He was posted between the period 2009 to 2014 as Circle Inspector Sadar Hazaribagh. He has been instrumental in recommending mutations in respect of 23 cases, which the list is there, Annexure A, Khata number 95, various plots which are forest land, prohibited forest land, including that recommendation made in respect of Khata number 95, 28 decimals belonging to Binay Singh and Snigdha Singh. Which he says that he had done it on the pressure of the Deputy Commissioner. Now, my lord, kindly just have a look to some of the paragraphs.
He himself has made a statement that that letter was issued by
him. Yes. In fact, my lord, kindly see his bail application.
Yes.
Just take, my lord, paragraph 15, 16 and then 18. 3 paragraphs.
Yes.
That the petitioner stated and submitted that after the submission of disfavor report for Dakhil Kharij, the petitioner has been called with the Circle Inspector Circle Sadar at the residence of the DC Hazaribagh in May 2010, where CO Alka Kumari was present in the residence of DC Binay Kumar Chaube. They asked him to change the report for Dakhil Kharij, the land Khata number 95, plot number 848, area 28 decimal, but the petitioner denied to do so and replied him that the concerned land belongs to Gair Majuba land, which land is shown as forest land in the record. It can't be changed, it can't change the report of Dakhil Kharij. So, I read that saying with respect to one plot, 848, I'll show all are government land, forest land. Now, kindly see para 16. That the petitioner stated and submitted that there is a lot of pressure to submit wrong report by upper officials. That then kindly come to para 18. This is important. that the petitioner stated and submitted that I am ready to become government witness and to support and cooperate to the investigating agency. Now, recording this submission, noting this submission, kindly see order dated 12/12/2020.
Yes.
I'll just read. Learned counsel appearing for this petitioner submit the petitioner is ready to cooperate with in investigation and only due to apprehension of arrest is not able to comply the notice under so and so. He submits that he has stated in para 18 of the petition that the petitioner is ready to become government witness. Learned counsel appearing for ACB submits that if the petitioner is ready to comply the statement made in para 18 of the petition, he may cooperate with ACB and unnecessarily the ACB will not harass. Even after this, my lord, he never cooperated with us. We have given the entire earlier notices issued to him. Now, my lord, on the merits, if your ladyship may see just for a moment, this is a case which is grave. In my counter affidavit, my lord, may come to annexure A, page 17. My lord, a list was kept at the office of the circle officer itself. Circle officer itself, annexure A, page 17. ये लिस्ट उनके यहाँ पे रखा हुआ था इस प्लॉट का. दिस सेम मतलब सदर अंचल गैर मौजूदा खास भूमि की सर्वेक्षण सूची ऊपर में प्रतिवेदी सूची हाथ से लिखा हुआ था. ये खाता नंबर है 95 सारा. और जो उसका जो प्लॉट है, देयर आर वेरियस प्लॉट्स, नॉट ओनली 848, 848, 1040, 776. एंड इसमें जो सिग्नेचर है ये इनका भी सिग्नेचर है, राजेंद्र सिंह. So this list was already there in the records of circle office that these plots are not for which mutation is required to be done. Despite that, my lord, all mutations have been done in, and her ladyship has seen in a manner in which the mutations have been done, my lord. And kindly see one more thing, my lord. In this
so
case,
in spite of having knowledge of this list,
he had done the mutation, and my lord,
he had recommended.
He has recommended for mutation. And my lord, the entire land records are missing. Now here it becomes important. Para 17. We have said that the land records that during course of investigation, IO of the present case made an attempt to correct the original records pertaining to 23 mutation cases, which were recommended to be done by the petitioner, upon which it was revealed that the land record that is Khatian pertaining to Khata number so and so, plot number 1 up to plot number 77 was found. But यहाँ पे एक was found available कर दीजिएगा. There is an error. Was found available at the circle office. And the land records in respect of land in question more particular was found to be missing and not traceable. तो यहाँ 773 तक missing था. उसके बाद का जितना plots है, that is the plots in question dispute, all land records were missing. And मतलब 18 onward we have given that repeatedly we had given him notice to appear cooperate, and he had not done so.
The learned counsel for the
एक सप्लीमेंट्री भी हम लोग दिए हैं. हम लोग वहाँ पर हाजिर भी हुए हैं जाके, लेकिन माना हमको वहाँ पर ये लोग entertain नहीं किए. This we have stated, my lord, and we have filed written, my lord, reply. Our statement we gave in writing, my lord. My supplementary is there. There are 3 or 4 and 5 of the supplementary. It is not that we are not cooperating. Attendance तक वहाँ
3, 4 and 5 में क्या लिखे हैं आप? ये पूरा कहानी लिखे हैं उसका.
Commissioner along with his son had gone to SP office in Jharkhand.
First supplement.
The second supplementary was the first supplement. The first supplementary.
15 onwards. 18/12/25
18/12/25 को आप गए हैं?
जी हाँ. The petitioner along with his son had gone to SP office of the Jharkhand, but the statement was not taken and was directed to surrender for deliberation. And then again on 9/1/26, the petitioner along with his son had gone to ACB office, but the statement was not taken and was directed to file the statement before the Honorable High Court. Thereafter, the petitioner has sent the written statement on 15/1/26 by speed post. This is what we have stated. It's not that we had gone there.
इसका क्या करना?
Yes, I just took instruction. But he never came. His son with some person came. कि हम सारा father के ब्याह में बता देंगे. But my officer is here, the investigating officer. He never came.
आप बताइए ना, कल का डेट फिक्स कर देते हैं आपके पास आने के लिए. चले जाइए कल 11 बजे.
चले जाइए.
जाइए अपियर होइए.
चले जाइए.
डे टू डे अपियर होइए, उसके बाद रखते हैं.
एकदम डे टू डे
15 दिन बाद.
इस बुढ़ापे में हम लोग नॉट गिवन अबाइड बाय. आज बेटी है मेरी शादी के लिए बुजुर्ग, अभी 15 साल के बाद हमको जो बुजुर्ग कहा जाएगा हम करेंगे. एंड नो ऑफेंस ब्लॉट इज मेड आउट, रॉन्ग स्टैंडिंग ब्लॉट सब फैक्ट्स कहीं पर कुछ नहीं, खाली ओपिनियन पर एफआईआर. And your lordship's judgments are there.
Records missing is very serious.
Yes, that is what I am saying. But in his case, it is serious.
The records missing is very serious. और सिर्फ आप अकेले नहीं है ना, हमको सबको देखना है.
Record missing अब आज 15 साल के बाद बुजुर्ग सब जो भी हो रहा है इस.
You see, you are not the only person. I have to take care of everybody.
Missing पर FIR नहीं है.
नहीं सना दर्ज है, हम लोग किए हैं अभी सना वहाँ
तो अलग से सना किए हो. अभी इस एफआईआर में कहीं मिसिंग पर बात नहीं है, उधर कोई एलिगेशन नहीं.
Just a moment. The learned counsel for the opposite party, while opposing the prayer, has referred to paragraph 7, page 21 of the, page 17 of the counter affidavit, and has submitted that a list of the property, all in relation to khata number 95, was already available with the petitioner, in connection with which the property was said to be forest land, and mutation was not to be done with respect to those properties. But in spite of that, the petitioner had recommended for mutation, being the circle inspector.
ये लिस्ट 18/25 का है.
नहीं ये अभी हमको अभी प्रमाणित करके 25 में.
नहीं नीचे देखा है.
The learned counsel, just a moment. The learned counsel has further referred.
It's not clear.
Just a moment. The learned counsel for the petitioner has opposite party has referred to paragraph 15, 16, and 18 of the anticipatory bail application, and has submitted that it is the specific case of the petitioner that he had initially made the recommendation denying mutation, but ultimately he was pressurized by the co-accused Vinay Kumar Chaubey, who was the then Deputy Commissioner, who had asked him to change the recommendation, and consequently he had changed the recommendation. The learned counsel submits that, and order dated 12/12/2025 was drawn by this court, wherein the fact that the petitioner wanted to cooperate with the investigation has been recorded, and it was also stated therein, it was also mentioned that if the petitioner is ready to comply the statement made in paragraph 18 of the anticipatory bail application and he may cooperate with ACB, the ACB will not harass the petitioner unnecessarily. The learned counsel submits that in spite of this order, there was no cooperation from the side of the petitioner, and on the face of the statements made by the petitioner in the anticipatory bail application, his role in the alleged offence cannot be denied, and therefore the petitioner is not entitled for anticipatory bail. To this, the learned counsel for the petitioner has referred to his supplementary affidavit and has stated that the petitioner had been to the office of ACB at Hazaribagh for the along with his son to cooperate for the investigation, but the ACB Hazaribagh did not entertain. ACB Hazaribagh होता है. Did not entertain the petitioner and did not record his statement. The counsel for the opposite party, upon instructions, has submitted that it was only the son of the petitioner who had approached and the petitioner never approached, and consequently the statement of the son of the petitioner could not have been recorded. However, he submits that in view of the statements made in the anticipatory bail application itself and in view of Annexure A, page 17 of the counter affidavit, the petitioner cannot be enlarged.
17 में जो लिस्ट दी है ना इसमें डेट नहीं है.
Because after hearing the learned counsel for the parties and considering the statements made in the anticipatory bail application itself, this court is of the considered view that the role of the petitioner in the alleged offence in the matter of transfer of forest land along with the other co-accused cannot be denied at this stage, and certainly the petitioner is not entitled for anticipatory bail. It further appears from the counter affidavit that the connected records with respect to the property involved in this case has gone missing, and therefore the likelihood of the petitioner tampering with the evidence also cannot be denied. Accordingly, this petition is hereby rejected. All to pass over था उसका क्या है?
Serial 17 is regular bail. One co-accused was just started bail. I'm only in regular. Two anticipatory bails can await the next trial.
राम प्रकाश चौधरी वो सेम है, सर्कल ऑफिसर है.
सर्कल ऑफिसर कहाँ है राम प्रकाश चौधरी?
सर्कल सब इंस्पेक्टर राम इनके राजेंद्र सिंह से जूनियर.
हाँ कहाँ है? Who is there for Ram Prakash Chaudhary? हाँ बताइए क्या बोलना है आपको राम प्रकाश चौधरी? सर गवर्नमेंट ऑफिशियल्स को मिलना था, बाकी हम ये पावर ऑफ अटॉर्नी होल्डर और सेलर उनको थोड़ा सा
पहले तो अभी सुना जाएगा कि अगले हफ्ते में इसको कल हम नहीं हैं, नहीं तो कल.
ठीक है. अगले आपका क्या है?
मेरा रेगुलर वेलेवर सेलर है ऑब्वियसली सेम एफआईआर जो लॉटरी मार्केट में इस वेलेवर में.
हां ठीक है, बट ऑनेस्टली ये भी बोले कि ये 13 में भी है जिसमें एंटीसिपेटरी बेल दूसरे का रिजेक्ट हो गया, वो भी कल
नहीं उसका सुप्रीम कोर्ट से बेल हो गया, वो आगे पहले रेडी है. एंटीसिपेटरी बेल कैन वेट फॉर वन मोर वीक. दिस पर्सन इज कस्टडी. दैट्स द ओनली रीजन.
I know.
And today only your options are granted bail to the co-accused will be easier for me.
Right.
17 is the next.
17. सेलर का बेल कौन से में हुआ है?
सेलर का हुआ है वो सीरियल 24
सीरियल
241701 of 2020.
सीरियल 24 का डिक्टेशन आप लिए हैं? कौन लिया है? बताइए सेलर कौन?
इसमें दो पिटिशनर्स हैं. हमारा टाइटल का जो ये है वो दिए हुए हैं हम लोग पैराग्राफ 3 से. And I am saying that there is a demarcation. The entire plot 1060 is not forest land. there was a demarcation done. Some of them was found to be forest and the remaining was not forest. And how it is my great grandfather was the Khatyani related. I have given the entire details of my title holders from paragraph 9 to 13. 12. And then 13 is my demarcation.
But so far as the mutation is concerned, you have no role. Mutation में तो आपका कोई रोल नहीं.
नहीं मेरा कोई रोल नहीं है. Some के forest का demarcated area से बाहर है. 1060 is a larger plot, some of which is forest. That is what paragraph 13 says. Plus, these are all old transactions. I am in custody for now more than 4.5 months from December.
December कब से?
6th of December 2025. That is 4.5 months.
The learned counsel for the petitioner submits that the petitioners are the seller of the property and the sale deed was executed in connection with khata number 95, plot number 1060, area
but different sale deeds are there.
Through different sale deeds. He has further submitted that the plot is a large plot and the entire plot is not the forest land. He has referred to the bail application and has submitted and has referred to paragraph number 13 to submit that as per the map, the property was demarcated by the forest department and the land sold does not fall as forest land. He has further submitted that otherwise also, so far as the allegation against, there is no allegation against the petitioner in the matter of mutation, which is the main allegation in the FIR. No role has been assigned to the petitioner in that connection. The learned counsel for the state has opposed the prayer. However, in the counter affidavit, no specific role of the petitioner has been mentioned in the matter of mutation done with respect to the properties so transferred.
Because there is a charge sheet submitted.
To this, counsel for the petitioner has submitted that the petitioner is in custody since 6/12/25. Petitioners are in custody since 6/12/25 and charge sheet has already been submitted. After hearing the learned counsel for the parties and considering the fact that the petitioners are the vendors of the property and as per the allegation, the specific role has been assigned with respect to the purchasers and who got the property mutated in connivance with the government officials. The petitioners are directed to pay in matrimonial. Co-accused का कौन सा co-accused?
हाँ, co-accused is मतलब
He has also submitted that the similarly placed co-accused has been enlarged on bail in BA number
1701 of 2026.
1701 of 2026.
The serial number 22.
What happened?
It was passed over. The petitioner is in custody for around 3 years.
अगला फ्राइडे को करेंगे. Passover you have taken at your own risk. इसमें हम कुछ नहीं बोल सकते.
If it is possible tomorrow.
Tomorrow is not the day. We have fixed day for these matters. That is on Thursday. We'll come on next Thursday.